And we're going to jump back in right where we left off last night. So we are in Unit 13, and we are switching gears from the sales side. Put the sales side down for a bit. And last night in Unit 13, we picked up the lease side. So right now we're just still talking about the relationship between the landlord or the tenant, the landlord and the tenant. I don't care if a property manager is involved or not. They're still supposed to follow. We talked about the North Carolina Residential Rental Agreement Act. We are in the throes of our Security Deposit Act. And guys, please understand that these acts have absolutely nothing to do with whether or not there's a broker or property manager involved or not. This defines the relationship between the landlord and the tenant. We're going to talk a little bit more about the Residential Rental Agreement Act tonight. But with the security deposit, and this is where we left each other last night, keep in mind a few things. First off, this only applies to residential leases. The Security Deposit Act doesn't apply to commercial. It's residential only. And basically what the deposit says, or the Deposit Act says, is that first off, it limits how much the landlord can collect. So there can't be like an open-ended, they'll collect thousands of dollars or something. It limits how much they can collect. We'll see that next. But the other big thing that the security deposit does is it regulates how much, if any, can be returned to the tenant at the end of the tenancy. You can't touch this money during the tenancy. This is not here for repairs during the tenancy. This is meant to be handled, and it will be handled after the tenancy is over. So we're going to talk a little bit more about like wear and tear and what things can the deposit be withheld for and when the landlord has to send it back. But before we do that, understand some requirements with the Security Deposit Acts with the limits. If the onset of the tenancy is a week-to-week lease, then the most the landlord can collect for the security deposit is 2 weeks rent. If it's a month-to-month, the most they can collect is 1.5 months. And if it's longer, year-to-year, the most they can collect is 2 months. And again, that's at the onset of the tenancy. So if you enter into a year lease with a landlord, the max they can collect for the security deposit is 2 months rent. As we said last night, that needs to be in either a trust account, which we're going to talk about, or it also needs to be in a bond. If you're unlicensed, if you're an unlicensed landlord, the security deposit can go in a bond or a trust account. Please remember, you guys, once you get your license, you're going to be held to a higher standard. So if you're a landlord, once you're licensed, the security deposit can only go in a trust account. And again, we'll talk about that. I know some of you going, whatever, Julie, what's the big deal? I'll put it in a savings account. It'll be all right. Here's what the big deal is. The Tenant Security Deposit Act says if you don't have it in the proper place, if the landlord doesn't keep it in the bond or the trust account, depending, then the landlord is not entitled to any of it after the tenancy is over. So if you have a tenant that knows their rights, they may not, they may exercise their rights. So y'all, again, I don't need to know if you're a landlord now. I'm not asking, but if you are, I need you to make a note of that because I need you to, pay attention when we get to the trust account section. But you also need to take those couple extra steps to make sure you're getting that set up right, so you don't get your brand new license disciplined. Fair enough?
How would the tenant go about finding out that it wasn't held in a trust account?
Where the security deposit is to be the landlord should let the tenant know. And in most pre-printed leases, like for example, the one that NCAR provides for us, it has a space for the landlord to say the tenant or the security deposit is at, and then you list the bank, the address, the phone number. So it should be part of that lease agreement. Yep, somebody said it's on the lease. So you just got to notify the tenant. And again, you guys, this is what makes me sad about this unit. It does. And what makes me sad is it reminds me that some tenants don't know their rights. So the best thing I can tell is if you're a tenant, get yourself educated. I've given you a couple resources. If you know a tenant, or if you're not sure that their rights are that they're being treated fairly, properly per the acts, then help get them those resources, help get those resources so they can protect themselves. I mean, you and I know, what do we document?
Everything.
Everything. Does that apply just to you as a real estate broker? No, y'all, that's good advice for life. And I wish our tenants knew that as well. I wish our tenants would document their phone calls, document their emails, you know what I'm saying? They're communicating with the tenants. Because unfortunately, if they don't know to do this, if they don't know their rights, if it ever goes down, they don't have a leg to stand on. And I'm not going to stand here and tell you that all landlords are good. Y'all have heard of slumlords. They're real. They happen. They're out there. And while I'm certainly not, I know none of us are, I know we're not suggesting that. But again, it's overall about protecting and that's the big part of the Residential Rental Agreement Act, is about the tenants' rights. So the best you and I can do, especially as brokers, especially now that you guys know what you know, the best we can do is help educate our tenants. So last night we mentioned those Q&A brochures the Real Estate Commission provides. They're in Learn, Test, Pass in the Unit 13 material. So again, the big great places to start. Reach out to the North Carolina Real Estate Commission. What's their number one purpose?
Protect the public.
Yeah, to protect the public. Isn't the tenant the public? So that's what they're there for, you guys. And the landlord too. I'm not saying the landlord doesn't have any rights. I'm just saying the tenant is usually the party that doesn't know their rights. Does that make sense? So the best thing we can do is educate that tenant. Good. So security deposit requirements again, and this is the onset of the lease. You know, if we start with a year lease and we decide after that year lease to continue the tenancy, the onset of the lease was 1 year. And remember, this is just residential. So that 1 year lease, the most the landlord could take for the security deposit, the max that the landlord could take for the security deposit is 2 months rent. So now the tenancy is over, and the question is, what are the permitted uses? Well, remember, we can't touch this money during the tenancy. It remains in that trust account or that bond if that landlord is not a broker. So the tenancy is over, and now the question is, what can the owner use the money for? Well, they can use the money for things such as unpaid rent, delinquent rent. If the tenant didn't pay the last month because they knew they were moving out anyway, then the landlord could keep whatever the rent is, that portion of the security deposit. The landlord can also keep the rent for major damage to the property. And this does not include normal wear and tear. Remember, you guys, that tenant's been living there for, in most cases, a year. And some people live harder than others, you know, but normal wear and tear, you can expect the carpet worn, you can expect nail holes where they're hanging pictures, you can expect these things because they're living there. We're going to look at that normal wear and tear. But something else we said last night that I think is worth repeating, just again so that we hear it. Under the Residential Rental Agreement Act, the landlord can't pass the buck. They can't put the repairs off on the tenant. They can't say something like, well, if you fix the roof, you can deduct it from rent. Remember, the landlord, under the act, the landlord number one responsibility is to provide fit and habitable conditions. They cannot pass the buck onto the tenant. They cannot put that responsibility onto the tenant. So what is normal wear and tear? Like we said, and when we look in our books, we got some great examples on page 178. You know, normal wear and tear is just the result of somebody living there. So you might have a coffee stain on the carpet. You might have a pet stain. We're going to talk about pets in a second. Worn carpet. Can we hear the difference in worn carpet because that's your path from your bedroom to your kitchen versus somebody taking their box cutter and cutting out a corner of the carpet or something. That's not normal wear and tear. Normal people don't cut the carpet. So that would be something, if they did cut out a corner or a section of that carpet, that would be something that the landlord could keep the security deposit for. The landlord can't charge separately for cleaning fees in between tenants because, again, that's just their cost of doing business. So whenever this tenant moves out, if they need to come in and, paint or clean the carpets or whatever, that's just their cost of doing business. Now, if they do want to charge cleaning fees, and that is something that we could agree to at the tenancy, but I would say most landlords would just kind of, whatever they need to do to get the unit ready to rent again, then that's just something that they need to expense. That's just part of their cost of doing business. The other thing that the Security Deposit Act addresses is when the landlord has to refund the security deposit. So the Security Deposit Act says that the landlord has to refund within 30 days, or if they've been waiting on quotes and repairs, with a written extension with written notice, they can go up to 60 days. So maybe there is some major damage and they need their sheetrock guy to come in, or they need, somebody to come in and give them a quote. They got to account to the tenant within 30 days. And by account to the tenant, I mean either refund the security deposit or provide them in writing that they're still getting repairs, they're still getting quotes. So within 30 days, the tenant should hear something from the landlord, and then all of this should be settled within 60. And remember what we've been saying, you guys. Well, what if the tenant says they didn't do it? What if the landlord says they're responsible for it? What happens if two parties can't agree to agree?
Arbitration.
Arbitration, the judge will decide for them. So same things with the landlords and the tenants. If they can't agree to agree, then the judge will decide for them. Also, under the Security Deposit Act, pet deposits are mentioned. The landlord can charge a reasonable fee. They don't have a set amount, but the landlord can charge a reasonable fee for a pet deposit if they allow pets in the home. That pet deposit is non-refundable. What the tenant is paying for is the right, the privilege to have a pet. So it's not refundable because I let you live in my home and I let you live here with a pet. That's what you paid me for, was that right, that privilege. If the pet damages the property, if the pet gnaws on the baseboard or, whatever pets do, then they can use that money to repair from the security deposit. So the pet deposit is not like prepaying for damage that the pet does. All the pet deposit is doing is paying for the privilege of having a pet. There is one exception to the pet deposit, and that exception is service animals. You cannot charge a pet deposit for service animals because service animals aren't pets. They're service animals. Currently, the ADA only recognizes dogs as service animals. The landlord needs to see a service animal as an extension to the person with the disability. Having a service dog is no different than having a cane or a wheelchair. So they cannot deny a service animal and they can't charge a pet fee. And again, what if the service animal damages the property? Then they have the security deposit to make those repairs if they're not normal wear and tear. Questions on the security deposit? Yeah.
I'm sorry. Is an ESA considered a service animal?
What's an ESA? Emotional support animal. No.
Yes.
Emotional support animal and service animals are two different things.
Okay.
So ADA.
I'd heard that before. I didn't know if it applied. Okay.
Yeah. ADA and fair housing. Now, the landlord and the tenant could agree for, cats or hamsters or, whatever. But the ADA, remember, that's your public accommodations. So if you have a service animal, you can't be denied entry into the store or the retail because you have a service animal. Landlord and tenant, they could follow more federal fair housing, which as long as I have permission, as long as I have approval, bunny, whatever, potbelly pig, as long as we know what it is and we call it a pet, then that's going to work. That's going to fly. If your rental is pet free, can you deny a service dog? No, because under fair housing, service dogs are not seen as pets. If you deny service dog, you're denying that person with that handicap or disability, which means you're violating fair housing. There's a lot to think about before you open up your home and allow tenants to live there. There's a lot to think about. Other questions on the Security Deposit Act? So in this next section, we're going to differentiate. I got a couple of different types of leasehold estates. So we're going to refresh what a leasehold estate is and then talk about the different types. And then we're going to talk about the different use for each lease. So there's different leasehold estates and there's different types of leases. And we're going to talk about what those different types of leases look like. So first off, we've seen this before. We saw this in Unit 2 when we started talking about our freehold estates. We also have this in our Google Drive. So if you want this chart to kind of help you identify the different types of estates and how that all works, you do have that in our Google Drive. Does anybody remember when I say estate, what's the one word that you should think of? The one word that should come to mind when we say estate.
Property.
Interest.
That's it. When I say estate, what we're referring to is the interest that one has in the property. So a freehold estate is an interest of ownership. Where we are as a non-freehold estate, also referred to as a leasehold estate. And the leasehold estate is the interest is possession. You are allowed to live there. You are allowed to possess and use the property. So we got a couple different types of leasehold estates. You can see them there in the red circle. And we're going to talk about all four of these and what they mean. So first off, we have an estate for years, also known as a tenancy for years. With an estate for years, you have a definite time period. And when it's over, it's over. No notice is required. We enter into this lease knowing it's going to start on this date and it's going to end on that date. Please don't let the name fool you. An estate for years is not necessarily for a year or more. An estate for years could be for years. It could be for a month, a week, a day. What makes it an estate for years, because we have a definite beginning date and a definite ending date. And when it's over, it's over. I don't need to give you notice. You don't need to give me notice. We know we're done because we agreed to this when we entered into this relationship. Another type of leasehold estate is an estate from period to period or a tenancy from period to period. With these, the tenancy is going to automatically renew until somebody ends it, landlord or tenant end it. So we have a beginning date and we're just going to renew it until one of us ends it. It's not uncommon for an estate for years to turn into a periodic tenancy. So you rented my home for a year, and at the end of the year, we decide we got a good thing going on. I'm providing you fit and habitable conditions. You're paying rent on time. I'm happy. So let's just go ahead and do an automatic renewal until we decide to end it. What we have just entered into is we went from an estate from years, and then we went into a periodic tenancy. Yes, ma'am, Stephanie.
So this is the tenancy from year to year in our book.
It says estate or tenancy for years on
No.
178. Then
179.
this is the, and you can see there also called estate from year to year, period to period, periodic estate, or periodic tenancy.
Oh, thought I just kept reading. Okay. Thank you.
So years to years, we have a definite end date. Period to period, we don't. One of us has to end it. And we need to give each other notice. Typically speaking, it's going to be a 30-day notice. I'm moving out in 30 days. I need you to move out in 30 days. Giving each other notice. Another leasehold estate that we have is called estate at will, also known as tenancy at will. And with this one, it can just end. We don't need to give each other notice. Either one of us can just end it. The difference between this one and the periodic tenancy has to be ended. This one does not. With this one, the tenant is there at the will of the landlord. The landlord is letting them live there. And I'll let you know, or you'll let me know when it's over. Notice is not required. This one's a little bit more risky for both parties, isn't it? So I'd say we see this one not as common as a periodic tenancy. You think we want some kind of at least verbal agreement. Hey man, when you're ready to move out, will you give me 30-day notice? We have an express periodic tenancy. We have that express understanding, that express agreement. The last leasehold estate then is called an estate at sufferance or a tenancy at sufferance. In this one, somebody's suffering. And who's suffering? The landlord. Because what they got themselves a squatter. Remember, if you stay, you pay. So if somebody's there, somebody's living there without paying rent, then the landlord is dealing with a squatter. Usually these start as a legit lease. And then for whatever reason, the tenant won't leave. We will talk about the landlord's remedy. How do you get rid of a squatter? And we will talk about that in just a second. But with an estate at sufferance, the leases end, the terms have ended, or you have a tenant there that is not paying. If you stay, you pay. So with any four of these leasehold estates, at the end of the tenancy, whenever it's over, whenever it ends, or whenever we get our squatter out, the reversionary interest is going to go back to the landlord. Remember, it is their home. They do own it. So once that tenant's out, the possession returns back to the landlord. Maybe they want to find another tenant to give new possession to. Maybe they want to sell it. But that the owner, the landlord, has that reversionary interest. And they can now do with the property. Now that the tenancy is over, they can now do with the property whatever they wish. Questions on the leasehold estates? Then we have different types of lease agreements. So most of these we can see, commercial, residential, land, etc. But we do have more common in residential, more common in commercial. So we're going to specify what the more common is. But when we talk about these different types of lease agreements, the thing that we're going to hear, the thing that makes them different is how rent is paid, but more importantly, what's included or not included in rent. So the first type of lease agreement that we have is called a gross lease, also known as a fixed lease, also known as a level lease, also known as a flat lease. I really guess it depends on who you're talking to. So with this fixed lease, the tenant pays the rent, the landlord pays the property bills, taxes, homeowner's insurance, maintenance. So the tenant pays the rent, the landlord pays the property bills. This is typically what we see most often with residential leases. Now, do you think these bills and taxes and insurance is rolled into what I charge you for rent? Oh yeah, absolutely. Absolutely. But you pay me, I pay the bills, the property bills. Now you're still going to pay utilities, that kind of thing, if that's what we agree to. But this is typically what we see most often with a residential lease. We also have a full service lease. This is where the tenant pays the landlord. And rolled into the cost of the lease is going to be things such as the janitorial crew, security, supplies, utilities. These are going to be more commonly found with a commercial lease. So think about like a large office complex or something. There might just be one maintenance crew for the whole building. There might just be one security for the whole building. So part of your rent is going to include those common services that the building may utilize. Another type of lease agreement we might see is called a net lease. With a net lease, the tenant pays the landlord, and then they also pay the property expenses. So in addition to paying the landlord, they may be responsible for the taxes, the insurance, common area maintenance. They're writing multiple checks. So you pay the landlord, and then you're also responsible for some property expenses. These are also most commonly found with commercial properties. Another type of lease is called a percentage lease. Think of your retail centers, your shop or your malls. So we're talking about commercial. And with these, rent is calculated two ways. One, we're going to charge you a base rent, probably on the square footage that you occupy. So for example, if we went back in the day when malls were still cool and fun, Claire's isn't going to have as big of a rate of a base rent as Sears is, because Sears has more square footage. Sears takes up more space. So if we charge that base rent just based on your square footage, and that's what you owe every month, because that's what you're renting. And in addition to that base rent, the tenant will also pay a percentage of their sales, of their gross income. So we'd have it in our lease agreement. You make more than X amount a year, then we're going to pay X amount on that overage, on that amount over. So it comes from two places. It's a small base rent for the square footage, and it's also a percentage of your income, a percentage of your gross income. I know you're not going to see a math problem on this, but I do think looking at a math problem kind of helps us see what we're saying. So I don't want you guys to get excited. You don't even have to pick up your calculator. I'm going to do all the work. Fair enough? Let's just kind of see how this would play out. So commercial tenant agrees to a percentage lease. The lease calls for a base rent of $1,500 per month and 5% of sales greater than $200,000. What is the annual rent for the tenant if the annual sales are 1.5 million? So the first thing we want to do is figure out that base rent. And you owe me $1,500 a month, regardless of your sales. That's just for you to pay for the space. So it's based off of the square footage. These smaller stores will pay less than the bigger stores because they occupy less space. So that's one piece of it, is the base rent. The second piece is the percentage of your sales. So this particular agreement says anything over 200,000. And it looks like they had a really good year. Y'all think the landlord's going to adjust that lease next year? Probably, right? So they had a good year. They had 1.5 million in sales, but they only have to pay lease on any differences of over 200,000. So if we take out that 200,000, all they'll have to pay that percentage on is 1.3. It's better than 1.5, right? So they kind of gave you the first 200 in sales for free. They said you're going to pay 5% on anything over that 200,000. So 5% is 65,000. And then the last thing we do is take the base rent plus the percentage over the sales. And we learned that this tenant's annual rent would be $83,000. Divide that by 12, and that's how much you're going to pay me each month. Next year, I'm going to need to see your books to recalculate that percentage. It's going to be from year to year. I had to finish it out. $6,917 is what you owe me for monthly rent. I couldn't sleep not knowing that, so I'm glad I. Questions on the percentage lease? Yeah, somebody says that's good money. Y'all, it was not cheap to have your store in the mall. It was not cheap to have a store in the mall. Maybe that's kind of what happened, malls, hey? The internet. Questions on that?
You told us that nothing is coming in the exam about this, right? Yesterday?
Correct.
You said that. Okay.
I just said it again too. Yes, ma'am. Another type of lease we might see is a ground lease. These are long-term leases, y'all. Think like 99 years. These are long-term leases. So with the ground lease, the tenant rents the land. The tenant only pays rent on the dirt, and then the tenant builds the building. This is why these are long-term leases. You going to build a building for a 3-year lease? Probably not. So you rent the land, you pay rent on that land every year, and then the tenant is responsible for construction and maintenance of the building. I've always heard, I don't know if I'm right or not, but I've always heard this is how Walmart operates. Say what you want to about Walmart, but they're brilliant. They charge you rent the land, you build a Walmart on the land, and in addition to collecting rent each month on the land, they're also getting a percentage of the proceeds of the sales. It's genius. I wish if I had a time machine, y'all know what I would do? I'd go back in time and I'd buy a good chunk of land, specifically a chunk of land that Verizon wanted to build a cell phone tower on. I wish I had that land that Verizon said, man, we want to put a cell phone tower here, because they would rent the land from me and then they would build their cell phone tower. They would be responsible for their own cell phone tower. It's brilliant. It's that old saying, y'all, buy land. They're not making any more of it. So, and as we can imagine, these are going to be commercial transactions, commercial leases.
So on like if the tenant were not to pay the rent on this lease or the monthly, what happens? I guess how do they get evicted?
Yeah, I would hope that would be spelled out in the lease somewhere, Angel. Like, what do you do? Do I give you 3 notices and then I take you to court, or I show up with my wrecking ball and knock your building down? I mean, I'd like to think that that would be spelled out. But yeah, that's a great question. Nice. Another type of lease agreement is called a graduated lease. With this, lease is going to increase at predetermined set intervals. You're going to rent for me for, I don't know, 10 years. And year 2, rent's going to go up. Year 5, rent's going to go up. Year 8, rent's going to go up. We decide when rent increases. This is mostly found in commercial transactions. And with these, I always think of like a startup business. I'm just getting started. I'm not making a lot of money right now. So graduated lease would allow me to increase my rent as hopefully my startup business, my business is growing, my business is increasing. We also have an index lease. With an index lease, rent can go up or down. With an index lease, it's based on some kind of index. For example, the government's cost of living index, maybe the consumer price index. But we agree to follow this index. And when the index goes up, when the government's cost of living goes up, rent goes up. Government cost of living goes down, rent goes down. And again, these are mostly found in commercial leases. From the onset are usually a lot longer than residential. You're not going to find many commercial leases that don't start with less than like 2 or 3 years. So when we're talking about a commercial lease, we're like 3 years, 5 years, 20 years. Residential, we're so used to annual leases. But with the commercial, I mean, think about it. This person, most of these are commercial. So they got to like have their business here, run there. They can't afford to move every year, so they're going to enter into a long-term lease. And that's usually how commercial properties start. There is also an oil and mineral lease. If the owner has leased their subsurface rights, part of leasing your subsurface rights is allowing somebody to come on your property and drill or mine. You might get the rent for the land. You might get some of the royalties of the oils and the minerals. It's all got to be spelled out on the lease. And these are going to be land leases. You don't have a structure. You don't have the rights or the access to the structure. You're just there for the land or whatever's underneath the land. Questions about our different types of leases, lease agreements. Next little section, we're going to talk about the essential elements of a lease. This should look pretty familiar to us. And then we're going to talk about, other than those essential elements, some common lease provisions. So everybody always please remember, a lease is a bilateral contract. A lease is a contract, which means it follows the same rules as what we discussed about the contract in Unit 8. So what are the essential elements of a lease? They're the exact same things as the essential elements of any contract. You have to have that mutual agreement. Landlord and tenant have to agree to enter into this lease, agreeing to the terms. We have to agree to the rent. We have to agree to the term. We have to agree to the security deposit and any other special provisions that might be included in the lease. There's got to be consideration, something of value. So with the lease, we're talking about rent. Legal capacity of the parties, and then legal objective. You cannot have a legal contract for an illegal purpose. Does anybody remember what the statute of frauds says about leases? Does
Three
it
or
have to
more.
be in writing? Say it.
Oh,
does-
have to be in writing?
Must
Does
be
it have to be?
after 3 years.
3 years or more, yeah.
Yep. Statute of frauds says the lease only has to be in writing if from the onset, from the making, it is 3 or more years. 3 years doesn't have to be in writing. 3 years and 1 day does. Now let's break this down. Does it make just good sense to put any lease in writing? If you were going to rent my home for the weekend, wouldn't we want to put that in writing? Yes, and I agree with you guys. But this is one of those places we like to get in our own way. For your exams, when they ask you about the statute of frauds, it's more than 3 years. Can you put it in less than 3 years? Yes. But the statute of frauds requires more than 3 years, has to be in writing. And by the way, the Connor Act parallels that. So Connor says any leases more than 3 years. What does Connor require us to do?
Record.
Record. So anything more than 3 years, Connor says it's got to be recorded. Statute of fraud says it has to be in writing. Julie's saying put all leases in writing. But the test is not going to ask you what Julie thinks. The test is not going to ask you what you think. It's going to ask you what the statute of fraud says. Everybody hearing me? So now that we have those essential elements, again, if we take this lease to the judge and say, hey, is this thing valid? This is what the judge is looking for. They're looking for those essential elements: mutual agreement, consideration, capacity of the party, and legal objective. In addition to what the judge is looking for, it's not uncommon to see other common provisions in a lease. So most leases are going to have some kind of term in the renewal. They may even spell out what kind of tenancy it is, what kind of leasehold estate it is. A lease will probably have some kind of default remedy. What happens if the landlord doesn't provide fit and habitable conditions? What happens if the tenant doesn't pay rent or maintain the property? We will talk about that in just a minute. So the default remedies, they may even say something like, look, if we have to hash this out, let's just go to mediation instead of taking each other to trial. So their default remedies may spell that out. Some leases may have an option to purchase or a first right of refusal. Talked about both of these in Unit 8. These were our alternative conveyance options. So you could enter into a lease with an option to purchase. At the end of the lease, you either buy it or you don't. You could enter into a lease with the right of first refusal, which means whenever the landlord decides to sell, they have to come to you first. They're legally or contractually obligated to come to you first. Particularly residential leases, the landlord's got to give themselves the right to enter. Without this right to enter, the landlord has no right to enter the property that they own. So most leases will have some kind of provision. I can come into the property with a 24-hour notice or a 48-hour notice, something like that. Most leases, again, particularly residential, will have that covenant of quiet enjoyment, which means the landlord's not going to enter the property without notice unless it's an emergency. They're not going to stalk the tenant. They're not going to drive by and harass them. Everybody, tenant, owner, we all have that right to quiet enjoyment. We have the right to sit in our homes and not worry about interference or disruption from the landlord. Some other common provisions. Think more with commercial, but residential as well. The tenant's use of the premises. How are they going to use the premises? Are there restrictions? So like this retail center, the shopping center, for example, the shopping center may have a restriction that says you can only have one restaurant that serves pizza. So if somebody there is already serving pizza and you want to open up a pizza joint, you're not going to be able to because of those restrictions. Residential, the use of the premises, the landlord and property manager, if there's one involved, needs to make sure that the tenant is following zoning and covenants if we're in an HOA. Commercial leases may have an HOA. So making sure that the tenant is following the rules, if you will. And if there's any restrictions on the use, then that should be spelled out in the lease. Any environmental concerns? I'm thinking commercial buildings, industrial warehouses, that kind of thing. Making sure that the tenant is properly disposing of any hazardous materials. If there's environmental concerns, y'all, they're not calling the tenant. They're not calling the property manager if there's one. They're going straight to the owner of record. Every once in a while you hear on the news, I hadn't heard it in a while, thank goodness, but every once in a while I used to hear on the news about like restaurants that were caught dumping their grease in the creek out back. Yeah, that's an environmental concern. And when they trace it back to the source, they're going after the owner. So again, depending on the use, is it a restaurant? Is it a chemical plant? Is it something dealing with an environmental concern? Then there may be a provision in there in the lease addressing that. Residential leases may have a provision about fixtures. Can the tenant install fixtures? Commercial leases may address trade fixtures. Remember trade fixtures? Trade fixtures is like our exception to fixtures. And with trade fixtures for the commercial tenant, they can come in, they can install fixtures to conduct their trade. And at the end of the tenancy, they can take those fixtures with them. So if you're a retail or a restaurant tenant, then there's probably a provision. Some residential landlords will let you install fixtures. Whether or not you can take them with you at the end of the tenancy should be spelled out in the lease. Check your lease before you start putting ceiling fans up everywhere or something, right?
Agricultural fixtures were the ones that stayed whenever the tenant left, correct?
Yep. Agricultural stays. Yep. Commercial leases may have some kind of upfitting or upfit improvements. Most commercial leases kind of start with a blank slate. Like so blank, we might even be looking at the studs, the steel studs. So the tenant is usually given an upfitting allowance. They're given X amount by the landlord to come and upfit the space, make it work for them. If the tenant goes over that allowance, and they would be responsible for the differences. So if there's any upfitting improvements, expenses, and how much, that should be spelled out in the lease. And then whether or not the lease can be assigned or sublet. An assignment means you're transferring all your rights and responsibilities. With an assignment, the only thing that changes is the names of one of the parties. If you sublet your lease, if you sublease, you're still keeping some of that responsibility. You're letting somebody else take over your lease, but you're still ultimately responsible. If they don't pay, then the second call they're going to make is to you. So an assignment's transferring it all. A sublease, you're still on the hook. You still have a little bit of liability. Whether or not you can assign a lease or sublet a lease has to be spelled out in the lease. So again, just some common provisions. I mean, remember, the parties can agree to whatever they want to agree to as long as it's legal, as long as they're not breaking any laws or acts or rules. But again, just some things that it's not uncommon to see in a lease. Questions? Take a break. back. So I'm taking attendance. Gone to your end. Let me get that again. There you go. Nope, I got you. Chat, I just took attendance, so let me know you're back in the chat. Okay. Let's talk about maintaining the property. Again, may this be residential or commercial. So the tenant has a duty to maintain the property throughout the premises, but of course the landlord will still have some responsibilities as well. And when it comes to maintenance, there's a couple areas that the landlord can focus on. So preventative, just trying to eliminate any costly repairs. So, changing the furnace filter or, the routine, the day-to-day things. So we don't have these costly repairs, costly expenses. So just maintaining, preventing any costly repairs. Corrective would be fulfilling the owner's responsibility. Corrective would be fixing something that broke. So the tenant calls the landlord and says this isn't working or whatever. And again, it's not, the tenant's wishes and desires. It's for residential, whether or not the landlord is providing those fit and habitable conditions. And if you're interested, the Residential Rental Agreement Act will spell out what those fit and habitable conditions are. So like, for example, heat is required, AC is a luxury. So just because the tenant wants AC doesn't mean that the landlord has to comply. If the HVAC system goes out, then the landlord has a duty to make sure that they fix that. And then again, commercial or residential, the landlord might be responsible for just routine things, housekeeping, ground maintenance. Think about residential, think about one of those large apartment complexes where you have common areas, parks and pools and clubhouses, that kind of thing. The landlord would be responsible for the grounds. The tenant would be responsible for the individual apartment, the unit. Especially residential landlords, it's a good idea to go in and check on your systems every once in a while. Make sure those furnace filters are getting changed. Remember, you can only do so with permission in the lease. 48 hours example. But just going in every once in a while and checking, putting your eyes on it. It's going to protect your investment. It's going to preserve your investment. You may also have some water leaking, causing damage to the subflooring, that kind of thing. I think particularly in residential, tenants are really going to only say something if there's something like really wrong, but if leaks, things like this, furnace filters that may not feel that they don't affect them, they may not report them. They may not report the minor things that turn into big things. So again, especially residential landlords, just make it a point to get in your property every once in a while. Just make it a point to go put your eyes on it. Commercial, again, same idea. You can go check on it, but you have to have that notice, whatever we agree to in the lease. I hope what we're hearing, agree to it in the lease. As long as it's spelled out in the lease and it's very clear about what each party's responsibility is. The NC Realtors, the forms, we do have a whole section set aside when a property manager is involved and they have access to the NC forms. So you'll have, if property management's where you're going, you'll have pre-printed leases and addendas and amendments and that kind of thing. But remember, you guys, if that pre-printed lease from NC Realtors doesn't fit your situation, then somebody's attorney is going to have to draft that up. Even though you're a property manager, you still can't draft. So then with this section, we're going to talk about how leases end, and we're going to talk about those evictions, how the tenant could evict themselves. The landlord could also evict the tenant. So we're going to talk about how we get rid of that squatter, for example. So first off, how do leases end? Well, very similar to sales contracts or any kind of contract. If we have an expiration date, we have an estate for years, we have a definite end date, and when it's over, it's over. We could agree to extend it, but we don't have to because we agreed to a date when we entered into this relationship. Prior notice, if anybody wants to end it. So that periodic tenancy, I'll give you 30 days notice or 45 days notice that I'm moving out or I need you to move out. Surrender and acceptance, they could, just kind of agree. Remember, the parties agreed to get into the lease together. So the parties can agree to get out of the lease. Abandonment, if the tenant skips out in the middle of the night, they do that sometimes. Pack up their stuff, take the toilet paper. Sometimes they take the kitchen cabinets with them. Ceiling fans, oh yeah, they jerk it all down, take it all with them. This all happens in the middle of the night. There are risks involved when you let somebody live in your home. So if the tenant skips out in the middle of the night, that will terminate the lease. Abandonment will terminate the lease. If the tenant buys the property, they're now the owner. So if we merge or if we do that right of first refusal and the tenant agrees to purchase the property. Destruction of the property, if the house burns down, for example, that would terminate the lease. Hopefully both parties are properly insured. Hopefully your landlord has homeowner's insurance for the structure and the grounds, and the tenant has renter's insurance for their stuff.
Can you require renter's insurance?
Yep. And that's something we often see in leases. Not only am I going to say I require my tenant to have tenant's insurance, but I want to know who you're going with. So that's absolutely something we often see in leases. And then condemnation of the property. If the court takes the property for any reason, eminent domain, the process is condemnation, then that would terminate, that would effectively end the lease. So again, it's a contract. Don't let the name lease fool you. We're still talking about a bilateral contract here. Will a lease terminate upon the sale of the property? So the landlord decides to sell. What do you guys think? Is that going to terminate the lease?
No.
No.
Got your head shaking no? And I agree. As we said, when a buyer buys a lease with a valid lease, they buy honoring that lease. The tenant changes hands. Remember last night we learned how to prorate rent because the month of settlement, we're sharing that tenant, we're sharing that rent. So the lease, the sale of the property does not terminate the lease, valid lease. What about upon death of the landlord or the tenant? Is that going to terminate the lease?
No.
Remember what we said about contracts. Death is not an out. So with a lease, if the landlord or tenant pass away, then their heirs may still have the duty to continue on with the terms of the lease. Again, if we're dealing with a valid lease, there's something to be said about putting that thing in writing in case something happens. But the lease could, in a lease, that could write that out. All right, let's talk about eviction remedies. So the landlord has eviction remedies, the tenant has eviction remedies. Talking about the landlord first. If the tenant doesn't withhold their end of the deal, so maybe they stop paying rent, Or maybe they destroy the property. They're not maintaining it. They destroy it. If the tenant doesn't maintain their end of the lease, their end of the deal, then the landlord's only legal remedy is called summary ejectment. This is the landlord's only legal remedy. The landlord has to go to a judge and have the judge remove the tenant. So if the tenant becomes a squatter, then we did have a lease, but at the end of the lease, they refuse to move out and they stop paying, then the only thing that the landlord can do is actual eviction, more well known as summary ejectment. And with summary ejectment, we got to go stand in front of a judge. We're going to the magistrate. It's a process. Again, hopefully the landlord has these costs rolled into their cost of doing business, their expenses. But the landlord can't physically remove the tenant. The landlord has to have the judge remove them. The landlord can't engage in self-help ejectment. So you can't move the tenant stuff out on the front yard. You can't change the locks or put a padlock on the home while they're at work. You can't show up at the property with your shotgun and say, get out of my property, get out of my land. You guys heard me say legal remedy. Do we all have stories of other remedies that the landlords have taken? Of course we do. Is that what you're going to be tested on? Is that what the Residential Rental Agreement Act says? No. Summary ejectment, you guys. Yeah. Hey, Dan.
Question. Obviously, you're not allowed, but what if you have friends that decided to help you, but you didn't ask them for the help?
Dan.
I have to ask.
I think a judge would see right through that. Well, I didn't kick him out, but Muddy Dan did. The only legal eviction is summary ejectment. Remember last night we mentioned the landlord can't engage in retaliatory eviction. So with retaliatory eviction, maybe the tenant makes the repairs. Is this not awful that this exists? What the landlord can't do when the tenant asks for repairs, they can't kick them out. Could you imagine that? Hey, fix my HVAC, you get out. The landlord can't do that. That's retaliatory eviction. Retaliatory eviction could also be like if the tenant is exercising their rights. So maybe they talk to an attorney, they can't be evicted because they talk to that attorney. Again, these things pop up on the news every once in a while. And the last one I remember seeing has been a couple years now. And it was an apartment building in downtown Greensboro. And y'all, they had all sorts of stuff going on. They had mold, they had pests and critters and all sorts of stuff going on. And the landlord was non-responsive. None of the tenants could get the landlord to call them back. So what did the tenants do? They went to 2 Wants to Know. They went to Channel 2 News, and they reported it. They did a whole story. And at the end, they said the landlord wasn't available for comment. Now, I don't remember a follow-up or anything to that, but what I do know when I saw that story, the landlord couldn't kick them out because they went to Channel 2 News. That would be retaliatory eviction, and you can't get kicked out for that. You also can't engage in self-help eviction. Summary ejectment. The landlord has an implied duty of the law of negligence, which means they have an implied duty to keep up with any common areas, maintaining any common areas. I mean, in this case, looks like that 2nd-story deck is on the ground. That could fall under the common law of negligence. So an apartment building or something like that, if the exterior lights on the building go out, the landlord's going to want to fix those. Just maintaining the common areas. Questions on the landlord's eviction remedy, what they can do and what they can't do. So the tenant has remedies as well. And the tenant's remedy, for example, maybe they're requesting repairs and the landlord's not responding. The tenant's eviction remedy is called constructive eviction. If the landlord fails to provide fit and habitable conditions, the tenant can make the report. They need to give the landlord a reasonable amount of time to respond. Reasonable amount of time. So they make the report. This is broke, this has mold, this is leaking, whatever. They make the report multiple times, multiple attempts, and the landlord makes no effort to respond. At that case, the only thing that the tenant, one thing that the tenant could do is essentially evict themselves. They cannot withhold rent. Because remember, if you stay, you pay. So they can't withhold rent. All they can do is evict themselves. And this is where I wish tenants knew their rights. So you call, let's say we have one of those big spring storms that come through, blow through real quick, and it damages numerous of roofs in the area. Tenant calls the landlord and says, my roof is leaking because of the storm. Landlord immediately calls the roofer, who says, I'm booked solid right now, but I'll get there in a week. Has the landlord done what they can do? I mean, tarps and pots and, that kind of thing, right? We can try to address it. But if they have done their part and contacted the roofer, there's nothing that the landlord can do about the fact that the roofer's backed up. Does that make sense? And that's why we say the tenant still needs to be reasonable. So it's not like you can call me and say, my HVAC's broke, and then 20 minutes later enact your right for constructive eviction because I haven't taken care of it. The tenant still needs to be reasonable. And what I wish the tenants knew is that they need to document the attempts that they make to the landlord. Because in most cases, these probably will wind up in front of the magistrates. And I fear if the tenants don't have that documentation, I called on this day, I texted on this day, whatever. So they have to give that reasonable amount of time to respond and to correct it. But remember, if they stay, they pay. So withholding rent is not an option because now the landlord's dealing with a squatter. So the tenants evicting themselves. So the HVAC unit burns up, there's plumbing leaks. Make your requests to the owner. Call your attorney if you need to. But if you're going to stay there, you still owe rent until it's fixed. You still owe rent. And that's why we say this is the tenant's remedy, is to evict themselves, is to kick themselves out. So what the tenant can't do under the act, it's no do it yourself. You can't use the rent to make repairs. You can't withhold rent until those repairs are made. This isn't a do it yourself project. Because remember, you guys, tenants, it's not your home. It's somebody else's home. And again, you also can't withhold rent. If you stay, you pay. So as mentioned in the residential lease, we said leases may be assignable. If they're assignable, you're transferring all your rights and liabilities, responsibilities to somebody else. Whether or not the lease is assignable, a good contract, any good contract should spell out whether or not the contract is assignable. Can it be assigned? Can you transfer transfer or release your rights to somebody else. And then the sublet, we said you're still transferring the lease, but the original tenant is going to remain liable. So with an assignment, all of that liability transfers. With the sublease, the original tenant still remains liable. So what I mean is if the new tenant doesn't pay, the landlord could go after both new tenant and old tenant to collect that rent. So subleases are obviously a little more risky, particularly if you don't know the person. But again, whether or not they can be assigned and or sublet should be spelled out in the lease. Questions on either party's eviction remedies? All right, so in this section, we're going to talk about the North Carolina Vacation Rental Act. Many Airbnbs may fall under this. Airbnbs were one of those things that kind of popped up overnight. Took the law a few minutes to catch up. But most of our Airbnbs, any vacation property, is going to fall under the North Carolina Vacation Rental Act. So first off, what is a vacation rental? Well, a vacation rental is defined as a residential unit that's leased for pleasure, for vacation, not business purposes. And that unit is rented for less than 90 days. So any of these properties, less than 90 days, residential, vacation, pleasure, will fall under the Vacation Rental Act. And under the act, the parties' obligations and duties to each other, well, it's still a residential unit. So the tenant has to, the landlord has to provide fit and habitable conditions. The tenant still cannot damage or destroy the property. So similar, they're just not long-term. Might be a week at the beach, a month at the mountain cabin, less than 90 days. Most vacation rental properties have security deposits. With vacation properties, security deposits can only be in a trust account, whether the owner has a real estate license or not. Security deposits cannot be in a bond. And remember, if it's a week to week, Security Deposit Act says the most you can collect is 2 weeks' rent. Occasionally, you provide your tenants of your vacation property such a lovely experience at the end of the week. They don't want to leave. Do we all feel like this the last day of the beach? Except for the couple of you that live at the beach. You don't know our pain. But for the rest of us, when the vacation is over, so what do you do if your vacation tenant doesn't leave? The Vacation Rental Act allows for an expedited eviction. So the landlord can give notice. They have to allow 4 hours after notice. And then after that 4 hours, they can request an emergency or expedited eviction process with the magistrate. So you go to clean the unit to get ready for the next tenant, and they're still there. Give them notice, give them 4 hours. And then after their 4 hours, if they're still there, then you got to go to a magistrate requesting that expedited eviction.
And during this period, I would assume we charged them as well, right?
Yeah. Yeah, because there should be something in the lease that is called a holdover fee. So every day you're there that you shouldn't be, and the judge will see that. And that holdover fee is usually pretty healthy. If the owner of the property that is being used as a vacation property, if the owner decides to sell, the new owner has to honor any existing agreements within 180 days of the sale. So whatever's on the books for the next 6 months after you buy it, you got to honor those reservations. Now, if you're buying it for a vacation property, you can keep everything you have on the books. But if you're buying it for your own personal property, just know you won't be able to move in if there are registrations, if there are reservations, I should say. So 180 days after the sale, those reservations have to be honored.
I have a question.
Yes.
Who gets the money for that?
Whomever the owner is.
The new
So
owner would
if
get
there's
that.
deposits, then they'll transfer, and the attorney will assist, kind of like the security deposit. The attorneys assist, and they're going to transfer it from the seller landlord to the buyer landlord when they become the new owner. My beach people, you're probably going to be dealing a lot more with vacation properties. I mean, Winston-Salem's lovely, but let's face it, people aren't vacationing here, you know. If I have anybody up in the mountains, I got somebody up in Asheville, you might be dealing with vacation properties. So what I have to say to you is North Carolina Vacation Rental Act, and what we just went through isn't enough. You need more education, you need more knowledge. So your BIC will have the resources because they do more vacation property stuff than what we do here in the Triad. Questions on vacation properties? All right, let's bring brokers into this mix. We've talked about the relationship with the landlord or the tenant. Now that we're bringing a property manager in, that landlord-tenant relationship isn't going to change. All the acts, all the laws are still going to apply. So we're going to talk about the authority of the broker when they're acting as a property manager. And we're going to talk about the property manager's main duties, their main responsibilities of being a property manager. And then I know that word says calculate, but we're going to look at how property management fees are paid. And don't get excited because it's pretty much the same as sales. We're usually paid a percentage on rent collected, not a percentage of the contract, but a percentage of rent collected. So let's talk first about the property manager. The property manager, think of the property manager as an extension of the owner. They're acting in the same capacity as the owner would. So the owner hires the property manager to manage their property on their behalf. Once an owner hires a property manager, what duties does the property manager owe the owner?
Old car, right?
It's old car. We're going to enter into an agency agreement, and the property manager owes the owner old car. Remind me, special, general, or universal? What is the classification of agency between owner and property manager?
General.
General, good job, guys. As a property manager, you're a general agent, which means you have some ability to bind. You have some authority to speak on behalf of the owner. You have some power. How much power, how much authority, how much limit? It's got to be spelled out in the property management agreement. So for example, the property management agreement, which is our agency agreement, that property management agreement may say something like, the property manager has the authority to make any and all repairs up to $500, which means if I'm your property manager and something breaks and it's $499, I just run out and fix it. I may FYI you about it later, but I don't need your permission to fix it. If something breaks and it's $501, now I have to call you. It got out of my authority. It got out of my relationship, that general agency relationship. So property managers and owners have a general agency. That makes sense, doesn't it? I mean, you hire me to manage your investment properties. And if I'm not a general agent, if I were a special agent, that would mean I'd have to call you for every stinking thing. Can I go get rent? Can I change the furnace filters? Can I start finding a new tenant after this one's moved out? And at some point you're going to go, what the heck am I paying this girl? She can't make a decision, right? So I've got to have some kind of authority to act on your behalf. Question comes in, what about painting? That may be an example of authority that the owner gives the property manager. It's a relationship that they have to create. And the owner and the property manager need to come into this understanding what the property manager is authorized to do without the owner's consent. I should be able to collect rent without getting your permission, right? I should be able to screen and select tenants. And that's why we say it's a general agency relationship. I'll keep it in mind that the property manager is an extension of the owner landlord. All right, one more question. Is the property manager required to do the working with real estate agent disclosure with the owner or tenant? Tenant or owner, either party, working with real estate agent disclosure. I'm getting some no's. Remember, you guys, the working with real estate agent disclosure is only required with sales transactions. This is our lease. So is working with real estate agent disclosure required with all transactions? No, just sales. It's not required with lease. Could the property manager do the working with real estate agent disclosure? Could they? Sure, absolutely. And many that I know do. They've created their own version of the work. Well, the attorneys created their own version of the working with real estate agent disclosure. But again, commission rule says that it's only required with sales transactions, not leases. Questions on that? The other thing to understand about the property management agreement, it's an agency agreement. So everything we talked about in Unit 3 applies when we're talking about property management. The property management agreement is different than the lease. The property management agreement is between the owner and the broker. The lease is between the landlord and the tenant. So when the lease terminates, the property management relationship is still going. It is still happening. Lease termination does not end the property management because it's an agency agreement versus a lease versus a contract between landlord and tenant. So yeah, general agent, the property manager has the authority to bind the owner to a lease agreement. They might be able to negotiate on their behalf. You know, the property manager is going to do a CMA. So them and the owner can know the probable lease price. And that's going to help us determine how much rent to collect. How negotiable is it? What are the different terms of the agreement? And oftentimes the property manager will have the authority to agree to or not agree to those terms on behalf of the owner. So please understand, and I think this is where we need to wrap our brains around this. The property manager is the broker of the owner. It's really rare in a residential transaction for the tenant to be represented. And even if they are represented, it won't be by that property manager. Dual agency and property management is incredibly rare. Commercial transactions, the tenant might come with their own representation. But in residential, the property manager works for the owner. But think about this. The property manager is the one that communicates with the tenant on the regular. They're the ones that collect rent and answer the calls and, go and check on the property every, couple months or quarter, whatever. So the property manager is communicating with and dealing with the tenant, but they need to make sure that they're not crossing that fine line and engaging in any activities that could be undisclosed dual agency. Their client is the owner. Their customer is the tenant. Why does the property manager collect rent? Because that's what's in the best interest of their client. Why do they do repairs? Why do they do maintenance? Because that's what's in the best interest of their client. So property managers need to be very, very careful that all they give the tenant is honesty, fairness, and the disclosure of material facts. The tenant is the customer. So those agency duties, the owner gets old car, the tenant is the customer, they get honesty, fairness, and we always have a duty to disclose material facts.
What would be an example of the implied dual agency on that?
If I start acting like I have the tenant's best interest, the tenant says, I know these really aren't fit in habitable conditions, but I want new wallpaper. Oh yeah, I'll give you new wallpaper, no problem. I just did what was best for the tenant because they wanted paint, they wanted wallpaper. Wallpaper doesn't give you fit and habitable conditions, right? Now, if we want to put new wallpaper, I say, well, let me talk to my landlord, see what they think, see if they approve this, if they want to do this. But if I were to make that decision, I'm now acting under the best interest of the tenant. My only responsibility is to make sure they have those fit and habitable conditions. The color of the walls, that's on them. So some duties and responsibilities of the property manager. Well, they have to plan. Tenants aren't going to be there forever. Tenants move out sometimes. Maybe the end of your lease is coming. Reach out to your tenant. Do you plan to renew? If not, then I need to start looking for other tenants. Because guys, if I don't have a tenant in place, ain't none of us getting paid, are we? The property manager's not getting paid. The landlord's not getting paid. So if we don't have a tenant in place, so we need to plan ahead. If you are looking for a new tenant, the property manager is going to advertise. They're going to advertise for this tenant. The property manager is going to be licensed, but they're allowed to negotiate. I'll tell you why this is here. Property managers often have unlicensed employees. It's really, really common for the property manager to have unlicensed employees. And remember, only the broker can negotiate. So they can't let their receptionist, their unlicensed employee, do the negotiations for them. The property manager is going to make sure that the home is properly insured. They're going to make sure that the homeowner is keeping their homeowner's insurance. They're going to make sure that the tenant has that tenant's insurance, that renter's insurance for their stuff. So they're going to make sure that they have insurance. Both parties are properly insured. Everything we've already talked about, the Residential Rental Agreement Act, the Tenant Security Deposit Act, all of that still applies. So the property manager and the owner now have a duty to make sure that they're following all these things. And in North Carolina, we don't have a separate license for property managers. Remember, we're all brokers. We're all brokers. It's what you choose to do. Do you choose to go into residential sales? Do you choose to go into commercial? Do you choose to go into property management? We are all brokers. And yeah, you could do all three if you wanted to. The Real Estate Commission isn't going to regulate your activities. They're just going to make sure you're following license law and commission rule. Does that make sense? They're never going to call you and say, what are you doing this year? Are you doing property management? So we all have the same license. It's just what you choose to do with that license. It's kind of like we discussed a long time ago, I feel like, but kind of like we discussed, you know, your real estate license gives you the authority to practice real estate with any property located within the state of North Carolina. But does that mean you're going to take on the entire state of North Carolina? Reasonable skill, care, and diligence says you pick an area, you pick a specialty, you pick the direction you want to go. And if you're going to tackle it all, then you need to be versed and experienced in it all. Does that make sense?
On the advertised part, does that mean that the property manager has to have a firm license too?
Yep. Yep. The property manager will have a firm license. They'll also have a broker in charge. They may, you know, the property manager is acting as the broker in charge in most cases. You're good. So yep, the firm's going to be licensed. Like we said, most property managers come with a whole bunch of unlicensed employees. So can a broker or property manager use an unlicensed employee, an unlicensed assistant? Of course they can, but there are some restrictions. The unlicensed employee can't negotiate. They can't change terms. The unlicensed employee can fill out pre-printed forms as long as the information they're filling out was provided to them by their employing broker, by their property manager. The unlicensed employee can fill in the blanks, but it's data entry only. Hand them a napkin with the terms and say, plug this into the lease. That's what we're talking about here. The other thing, the big difference in an unlicensed assistant for a property manager versus an unlicensed assistant for sales, residential sales, commercial sales. The sales unlicensed employee cannot show properties for sale. The property manager's unlicensed employees can show properties for rent. So if you ever rented an apartment at one of those large complexes, there's a good chance that somebody put you in the golf cart and gave you the grand tour of the complex. There's a really good chance that person driving the golf cart was an unlicensed employee. And they can show properties for rent. They cannot show properties for sale. So it's pretty basic. The property manager's primary responsibility is to realize the highest rate of return for the owner. What is the most rent that's reasonable for me to charge in this neighborhood, in this area at this time? Remember, they're doing their CMAs. They're looking at what rent goes for in the area, in the neighborhood, 3-bed, 2-bath, looking at parts of the properties that are similar. When you guys get into MLS, we got a whole tab just for property management. So you'll be able to see properties that are in for rent. You'll be able to see what the probable lease is. And once we determine what that probable lease is, then we've got to get with the owner and figure out what they want. What do they want their rate of return? And then see if we can make this happen. Because the owner still has property expenses. The owner has to pay us, don't they? They have to pay the property manager. So once you pay all these bills, the owner's question is, how much are you going to put in my pocket every month? So we're going to help them realize the highest rate of return for this market, for this neighborhood, that probable lease price. They're going to follow the owner's, there's that word there again, lawful instructions. Again, similar to what we talked to with sales. I follow my client's lawful instructions. The owner can't make the property manager break the laws. And by that, I mean police laws. I also mean license law and commission rule. And then the property manager has a duty to preserve the value of the property, because that's going to help the owner realize the rate of return. So they may suggest maintenance. They may suggest repairs. If we do this and this, then it'll last a lot longer. What do y'all think about a property manager? What do you think happens to their reputation if they're not managing the property, if they're not caring for the property? Do you think, yeah, I get thumbs down. Do you think word like that gets out quickly? And we know how social media works, right? So if you have a property manager that's not doing their job, I mean, everybody knows everybody. It's crazy to me how many people we know. You know people and people talk, you guys. So the property manager has to work for the owner, all while preserving their own reputation if they want to continue this relationship. And if that property manager eventually gets the reputation of not maintaining the property, not caring for the property, with allowing the owner to lose money, word like that's going to get out, and it's going to be hard for you to find. I would think it would be hard for you to find future owners. Remember, they're like giving you a piece of them. They're giving you that responsibility. Do they have to call you to manage their property? No, you don't have to have a property manager if you choose to. And it might be you have one property, it might be you have 10, and you're tired of running around all over town, so you hire that property manager to help you out. The property manager is going to also be responsible for collecting rent on time. If summary ejectment comes up, the property manager is probably the one that's going to go to the magistrate. They're probably going to be the ones to go to the small claim court to enact the summary ejectment. So handling vacancies, delinquent tenants, that kind of thing will be the responsibility of the property manager on behalf of the owner. The property manager is also going to be responsible for keeping not just records, but accurate records. We're going to talk about some reports that the property manager may run for the owner. I mean, the owner cares about what's happening with their money. So they may have to account to the owner once a quarter or once a month about what's happening to their money, what's happening to this investment. The owner is an investor. This property is an investment property. Everybody show me, how long do we keep records? A minimum of 3 years. 3 years, yep. So minimum of 3 years, and the property manager will keep accurate records. When did I collect rent? Rent will run through the trust account. From the trust account, I'll pay the maintenance, the janitorial, the landscaping, all the people I need to pay for the property. I'll pay myself from the trust account. And then the very last person that will pay will be the owner. Whatever's left, they will get. So we're going to have accurate records for 3 years. More on property managers' duties, and we're going to touch on what they can't do. But first, let's take a break. Let's take 10. Welcome back. So I am taking attendance. Still talking about our property manager, what their responsibilities are. So collecting rent, keeping accurate records. Property managers, when they receive rent, they're going to run it through the trust account. Remember, well, no, you don't, because we haven't talked about it yet, but we're going to learn that a trust account is an account that has somebody else's money. So when the property manager is collecting rent, they're collecting payment on behalf of the owner. So we're going to have to run it through a trust account. We're going to talk about the trust account in Unit 15. But it's got to run through the trust account because it's not the property manager's money. And then again, from there, from the trust account, the property manager will pay whatever maintenance bills, janitorial, they'll pay themselves. And then the last person they'll pay is the owner. So more on the trust account in our next unit. And again, you guys, property managers can pretty much do whatever them and the owner agree to. We can agree to these terms, but there are a few things that property managers cannot do on behalf of their owner. So what can they not do? They can't pay property taxes. That's still going to be the owner's responsibility. So the owner is responsible for making sure that they pay taxes every year. The property manager can't determine or do capital improvements. So adding square footage, adding a room at the back of the house, looking at this picture, finishing the unfinished basement. Now the property manager can make suggestions. They can suggest that the owner do these capital improvements. They can suggest that the owner update the bathrooms or the kitchen, whatever. But ultimately, doing capital improvements is the responsibility of the owner because it's their property. And the other thing the property manager cannot do is reinvest the owner's profits. It's their money. So they pay the owner, and then the owner decides what they're going to do with their profits, what they're going to do with their money. We've mentioned a couple times that the property manager needs to pay themselves. So how much is that property management fee? It's got to be spelled out in the property management agreement. The property management agreement is an agency agreement. And remember, our agency agreements are employment contracts. And all employment contracts need to spell out how are you going to get paid when you do the job that you've been hired to do. So commission is completely negotiable. We can't set fees. When the owner looks at you and says, how much do you charge? Don't say anything like, all of us in this area charge X amount. The firm, the property management firm, sets their fees, sets the commission. They could be a flat amount. They could also be a percentage of rent collected. I think if you're dealing with a handful of investment properties, we might be looking at percentage of rent collected. If you're dealing with one of those large apartment complexes, you very well may be looking at a flat fee. So it's just whatever the two agree to. So with the property management fee, if it is a percentage, please always remember it's a percentage of rent collected. So remember this, we talked about your potential gross income. This is your dream. See you tomorrow. This is your dream. If you had 100% occupancy 100% of the time, that would be your potential gross income. Is that realistic? To always have a tenant, always having a tenant paying on time? No. From that, we deduct our vacancy and collection losses to give us our effective gross income. So rent, specifically percentage, will be a percentage of rent collected, which means it would be a percentage of effective gross income. You may see this math. I think if you're going to see brokerage math, it's going to be on the residential sales that we talked about in Unit 3. But again, you may see property management math. Commission math could be sales or lease. So what I need you guys to do is make sure that you only charge a percentage of rent collected, which would be that effective gross income. And the question comes in, this is annual? Yes. This is annual, always calculated annually. And also don't forget, y'all watch out for those duplexes, triplexes, and quadplexes. So if it's a duplex that has, I don't know, $800 a month of rent, that means you have $1,600. So just make sure you're paying, read the question and you're paying attention to those words. I'm not going to make us do this because this is commission math that we did back in Unit 3. But again, what I need you guys to see, a percentage of rent collected. The potential gross income is not what you're collecting. What you're collecting is the effective gross income. Questions on that? Another big part of the property manager's responsibility is helping the owner account for their money. So there's going to be some reports. And one of the reports that the property management will do will be the annual operating budget. Budgets are always planned in advance. Let's predict how much income we're going to collect this year. Let's predict how much we're going to spend on janitorial, maintenance, landscaping, whatever. Let's project how much we're going to have, how much we're going to spend on repairs, on fixing things. Is there a good chance something will break this year? Sure. Do I know what? Not yet, but I got a budget for it. I have to plan for it. Some of you may do your own household budgeting, where you sit down at the beginning of the year and budget, plan on how we can take a vacation this year, how we can do birthday celebrations and holidays. You're planning in advance, you're budgeting. So the annual operating budget is a forecast of future income, future expenses. And we're going to have a lot of estimates. Again, I don't know what's going to break this year, but I need to have money set aside. I need to have budgeted that something will break. We're not going to include the debt service, your principal and interest payment. If we're going to save for any future expenditures, maybe it is time to update the kitchen. But before we can update the kitchen, the owner has to save some money. So how can we budget? And then again, and always keeping the goals of the owner in mind. At the end of the year, the property manager and the owner will go back to their budget to see how they did. How did we fare out? And looking from year to year to year, planning and budgeting from year to year to year will help us better predict next year. The relationship, thank you. The relationship with the property manager and the owner is hopefully one of a long-term relationship. Hopefully we can solidify this relationship. We can continue that agency agreement. Another report that the property manager may do for the owner is the cash flow analysis. And this just shows us how liquid our money is. How does we spend money? How to receive money? What's happening with that cash flow? Again, for the owner, they're the investor. And an investor cares about one thing. What's an investor care about? Their money. So they want to see how their money's flowing, how their money's spending, how it's going. And that's one thing that the property manager absolutely can assist the owner with. Another report is the profit and loss, also known as the P&L report. This shows your revenues and your expenses. P&L reports can be, monthly, quarterly, annually. It's just whatever the owner wants. So whatever reports we do, however often we do these, the property manager is going to have to report to the owner, because the owner is going to need to see what happens to their money. They're going to need to see what's happening to their investment. The property manager also has a duty to follow fair housing. Remember our protected classes, our fresh corn. So the property manager, especially when they're selecting and qualifying and screening tenants, remember the big picture. What you do for one, you do for all. So when you're looking for tenants, when you're qualifying tenants, if the property manager is going to pull one employment check, one employment record, then they need to do that for all of the tenants. If we're going to look at criminal background report, they need to do it for all. The property manager can't tell someone that a unit is not available when it's being actively marketed. If somebody comes in and says, I want to rent this unit, and it is out there on the internet, so you can find it everywhere that this unit is available for rent, and that property manager takes one look at you and says, no, this unit's not available, could you feel like you were discriminated against? Could you feel that for some reason? So if a unit's available, if it's being marketed, don't tell someone it's not available. You are opening the door for discrimination. And remember, the other big picture of fair housing says that everybody should have the right to live wherever they want, as long as it's within their financial means. So screening tenants, verifying their income, verifying their employment is absolutely allowed. But just always remember, what you do for one, you do for all. So whatever that policy is, screening tenants, probably have them fill out an application, maybe doing a credit check, maybe doing a background check, maybe doing an employment check. There's no right answer here. There's no wrong answer here. Just make sure you're doing it for all. But ideally with screening tenants, the property manager is trying to catch a problem before they move in, before we agree to enter into a lease. So whatever your policy is, or your property management's company policy is, when it comes to whatever these screening tenants criteria are, screening the tenants criteria, the property manager is usually going to be the one that sets the policies. And generally speaking, the owner doesn't care. They just want a tenant in place. So usually the property manager will select the screening policies or criteria at their own discretion. Of course, one of the big things that the property manager needs to make sure is that the tenant has the ability to pay. So that's where they may request employment records, employment checks, requesting to see that debt to income ratio, making sure they can pay. And it's all okay. Whatever you do is okay, as long as we do it for all tenants. What about with a large family? Maybe the home isn't large enough. Maybe the home isn't big enough. Could the owner, the manager refuse to rent to a family based on the size of the family? Generally speaking, I know we've talked about the on-site septic system. So if it's on an on-site septic system, then we want to make sure we stick to 2 human heartbeats per bedroom. However, that's a good rule of thumb with most bedroom sizes, modern bedroom sizes anyway. So septic system, yes, we have to make sure occupants 2 bedrooms. Other than that, the property manager and the owner may just have a policy on how many people can live in the home. And again, they can set the policy as long as it applies to all. The property manager may want to inquire about any previous convictions, specifically past drug convictions. If there are any past convictions or past drug convictions, the tenant can be refused. Thank you. Can be refused tenancy if that's the policy. Any conviction. The other thing, tenant comes home from work one day and there's an eviction notice on the front door. The landlord knows they're facing foreclosure, for example, they know. Do you think they're calling the tenant, let the tenant know they're going for getting ready to lose the property through foreclosure? No. So unfortunately, how this happens is the tenant comes home from work one day and they see an eviction notice on the door. These laws protecting the tenant in the event of foreclosure are fairly new. Prior to the housing market crash, there weren't any laws. So tenants were coming home from work, eviction notice, and they were stuck. They couldn't even get in the property to get their home. So another thing we got from the housing market crash was the need to protect a tenant if the owner lost the property to foreclosure. So the question is, if the landlord loses the property to foreclosure, is the new tenant going to reside in the property? If they're no, then we'll honor the lease for as long as the lease exists. But if they are going to stay, there's a 90-day notice to move. So the owner of the bank can't come in and just kick the tenant out. They need to give them a minimum of 90 days. And that is brand new post the housing market crash. So there's a valid lease. That's what we're saying with the 90 days. If there's a valid lease. We do have a sample property management agreement in Learn Test Pass. We're not looking at this. You're not going to be tested from the agency agreement like you will the exclusive right to sell and the exclusive buyer's agency agreement. But we do have property management agreement in Learn Test Pass if you want to look at it, or if you're going into property management, you may want to download it to peruse it later once you get that license before you get started. A common question I get about the property management agreement. Remember, you guys, all of our agency agreements, we're being hired to do a specific job. So the property management agreement, I'm just being hired to manage the property. So a common question I get, if I have a property management agreement and my owner decides to sell, can I list and sell their property under my property management agreement? Does my property management agreement give me authority to list and sell? And you guys are shaking your head no, and I agree. Because the only thing I'm allowed to do with a property management agreement is manage your property. So when the owner wakes up one day and decides they're ready to sell, if my firm practices sales, if we are engaged in residential sales, then we enter into an exclusive right to sell listing agreement. If my firm doesn't, then I can refer you to a firm up the street. And because I'm a broker with a current active license, I can collect a referral fee on that. So again, our agency agreements, we're being hired to do a very specific thing. And in the property management agreement, we're only have the authority to manage the property. Everybody good with that? Questions on that? The other thing about the property management agreement, it is an agency agreement, so we have our 4 musts. It must be signed by all parties. It must have the non-discrimination clause. It must have the broker's license number, and it must have a definite end date. So all those 4 musts of our agency agreement still applies. The property management agreement is the only agency agreement that will allow for an automatic renewal. So we have a definite end date, but it will allow for an automatic renewal. So as we just said, hopefully the property manager and the owner are forming this long-term relationship. The owner doesn't like changing property managers every year, right? So hopefully we're forming this long-term relationship. We enter into the agency agreement with a definite end date. Maybe it's a year, maybe it's 3. And at that definite end date, if we're doing good, if I'm making you money and I'm collecting rent and you're seeing the value of your investment property increase, then we can agree to keep going. Automatic renewal, property management agreement only. Questions on that? All right, well then it's my turn. Who's constructive eviction for? Whose remedy is that? Constructive eviction.
Tenant.
Tenant.
That's the tenant's remedy. So
Tenant.
what about actual eviction? Who's that remedy?
Landlord.
Landlord.
Actual eviction is also referred to as summary ejectment. So constructive eviction is the tenant's remedy. Actual eviction, also known as summary ejectment, is the landlord's remedy. Does the lease automatically terminate upon death of either party? And we're saying no, because
No.
remember, basic contract
No.
law, death is only an out when you're negotiating the offer. Once you're under contract, death is not an out. So the party's heirs, and we could put something in there that would terminate the lease if a party dies. So we can't add something to a lease. And that's why that word automatic is there. That's why we see that word automatic. What did we say a ground lease was?
For land?
99 years.
Years, yeah.
Yep, yep. So the
Oh.
ground lease is for the land. You're renting the land so you can build on it. What about the net lease? What are you paying with the net lease?
It's triple net. You're paying taxes, insurance, and the rent.
Yep, so you're paying your rent plus other property expenses. Both of these we generally see in commercial. And then we also talked about the various ways that leases can end, abandonment, end of the lease, termination date, pretty much the same thing was the contract. What I want to know is, will the end of the lease impact the property management agreement? And you guys are saying no. The property management agreement is between the landlord and the owner. I mean, the landlord and the broker. The lease is between the tenant and the landlord. It's two different agreements. It's like our agency agreement and our sales contract. Only now we're talking about the agency agreement in the lease. So when the lease ends, the property management agreement continues. By the way, another thing that we're going to see in the property management agreement is what happens when the property management agreement ends. Ideally, or typically, if your owner is getting a new property manager, then the property manager whose relationship is ending will need to turn those books over. They'll need to turn the information and the records over to the new property manager. So that should be spelled out. Can the broker deposit rent checks directly into their own bank account?
No.
No.
That's going to go in the trust account. We're going to talk about the trust account. Trying to build up hype here. When can we use a security deposit?
After
tenancy.
Yep. When the lease is over. You can't touch that money during the tenancy. The security deposit is meant to be there. It's meant to tie up loose ends after the tenancy. So if something breaks during the tenancy, that's just the landlord's cost of doing business. That's just their repair budget, whatever. And then what was the type of lease that we talked about with retail space, like malls, for example?
Percentage lease.
Yep. Yep. That's that percentage lease where we have like the base rent and then we have a percentage of rent collected. Kind of a rapid fire at you guys. Any questions on property management? So last night when I asked you guys if anybody was going into property management, I saw 2 hands go up. Has anybody changed their mind or thinking about changing their mind? Oh, there's another hand. Hey, we got another one. Yeah. So again, you guys, you know, and I hear you. I hear you. Some of you guys are going, my gosh, Delu, let me get my license first and then I'll figure it out. I hear you. I hear you. But just know, I think it's reassuring to know that we have options. So if you get out there in residential sales and that's not working out for you, look into commercial, look into property management, right? Look into other avenues and resources because as brokers, we have options. Questions? Just a couple reminders, make sure we're all good. First off, you guys have your exam dates and times. That exam window is opening up Saturday at 8 a.m. and it's open through Sunday. If you are eligible for the retake, then it's the same times. It's just the following weekend, the 22nd, the 23rd. Lane will be in touch with you guys after your final exam on the 16th. You'll probably hear from Lane on Monday. When you pass, she'll send you your certificate of completion. If you're eligible for the retake, she will send you instructions on that. If you don't make a 50%, she will send you what you can do on that. So what I'm telling you guys is pass, fail, or eligible from the retake. You're going to hear from Lane on Monday, but just please be very, very patient with Lane. Do you have to get a 75 on both tests or one? Remember, mine is just one test, 2 sections. So it's a 75% for the one exam. Another reminder I saw another email come out from Lane today for those of you that haven't paid yet. And I don't know who got it because you guys are BCC'd. But call Lane tomorrow. Call Lane tomorrow if you haven't paid, if you haven't gotten the link. Promise me. Because remember, we got to have these things by Friday morning. So the other thing I want to remind us of, I looked at our how we're doing with our part exam, and I got like 23% of you that are complete with the part exams. So I want to make sure that the rest of us are good. Okay, so you need to reach out to Lane because I'm not sure what you paid. So reach out to Lane to make sure that that's good. So guys, everybody, please look. Everybody. There are 3 part exams. Part 1 exam is after Unit 5. So if you haven't attempted the Part 1 exam yet, it's after Unit 5. The Part 2 exam is after Unit 10. So there's the Part 1 exam after Unit 5. There's the Part 2 exam after Unit 10. And then the Part 3 exam is after Unit 15. And please note, there are 2 sections with the Part 3 exam. There's a national section, a state section. I've seen a couple of you have done one, which is great, but I just want to make sure that you see it's one test. It's just 2 sections. And guys, all of this, the fee has to be paid, and I need you to attempt all 3 exams before, like Friday morning. Like I'm getting up about 6:30. That's usually when I get up. So I need you to do it Thursday night before you go to bed. Is everybody with me? What questions do I have?
So
Can I confirm who took all 3? Yes, just send me a message and I will be happy to respond, but I'm not going to do it here in class. So send me an email, send me a text, and I will be happy to confirm if I have all 3 parts. I will be happy to do that. I'm sorry, Ariana, was that you?
Yeah, but I think it's pretty self-explanatory, but that I had some confusion on it. Part 3 is pretty much an end of class practice test, not section, units 10 or 11 through 15. That's where I got confused. Okay, perfect. Thank you.
That Part 3 exam is your practice test. It's getting you ready. And I know we haven't done Unit 15, guys. We're getting ready to start it. But guess what? As we go through Unit 15, you're going to see much of this serves as a really good review. How many of you had the chance to look at Unit 15 before tonight? A few of you. And you saw things in there like agency agreements and working with real estate agent disclosure. So a lot of Unit 15. We're going to learn some new things, but a lot of Unit 15 is a review. So what I'm saying is we've learned, with the exception of a couple things, we've pretty much learned what we need to learn. So I don't want you guys to get intimidated by 15 because most of it we have covered in the previous units. Does that make sense? I'm keeping this open until Friday morning because I have a feeling some of you will do these tomorrow night after class. So that's why I'm giving you the evening. I'm giving you the opportunity. I would prefer if you don't do these during class. And this is what I'm concerned of now when we have so many that still need to complete these. Doing these during class would be considered a distraction and you're not getting the material from class. So please don't do these during class.
And
so
when
you have tomorrow night.
And when you say attempt them, you mean go in and answer all of them?
That's all I'm asking you to do. I'm not asking you to pass them. I'm asking you to attempt them. So there's 3. And the third one has 2 sections, as does your end of class exam and your state exam. So tomorrow night, it's my last chance to remind you. I'm curious to see if I'm going to have more than 22 or 23%. What questions, you guys understand we're running low. We're running low on time here. So what questions or comments do I have about these? And if you don't want to ask it in class, fantastic. Call me tomorrow. Text me tomorrow. Reach out to me tomorrow. Because tomorrow is pretty much the last opportunity we have to address these questions. I'm going to stop sharing just for 1 second. Watch it again. Unit 3 is a big one. So you got the recordings. Listen, if you need the Google Drive link, if you need the link to the YouTube channel, whatever you need, reach out to me tomorrow. All right. Big deep breath. Last unit, you guys. By the way, I've mentioned skipping 9, 12, and 14. I've recorded all 3 of those units and I put them in our YouTube channel. All 3 units, they're like 56 minutes for all 3 units. As we said, you can only expect to see a handful of questions of those on our end of class exam. You can expect to see a handful of questions from those, like 2 or 3, on your state exam. So when you're preparing for the state exam, you have the entire recording, you have the entire PowerPoints. Tomorrow, when we're done with unit 15, we're going to go through together and pick up the highlights. Nod, nod, wink, wink. So tomorrow night will be for your end of class exam, but you have the recordings, you have the full PowerPoints for your state exam. Is everybody good with that? So we'll touch on those highlights tomorrow. I'm sorry. So unit 15 is our license law and commission rule. This is our state specific section. The majority of this unit, not all of it, but the majority of this unit comes from the comments that you can find in the Learn Test Pass. Now we looked at that. It's up near the top in your resources. We actually started talking about this back in unit 3. This is the source. Those comments are the source for the end of class exam. So let's make sure that we're, so back up in the resources. There is full text. License law and commission rule. You have license law, you have commission rule, but all we asked you guys to focus on were the comments. Which are right here. So just make sure you're focusing on the comments. And again, this is the majority of your state specific section. And we're going to see in just a minute, I'm actually going to reference those comments so you can see where the comments you can find what it is that we're talking about. I went ahead and pulled it up from Learn Test Pass so we could see it, because there are a few times that we're going to come out here and look at it. So we want to make sure we're good. Questions on where we find the comments, where we are, what we're looking at? Looks like I got something in the chat. Correct, Michael. So the comments, guys, this is the majority of your state specific section. So all the buildup, all the hype, unit 15. It's a good one. Much of it's review. So with unit 15, we got a couple of references. First off, you have unit 15 in your textbook, and then we also have the comments. So one thing you're going to start noticing on these PowerPoint slides is we're going to reference. C stands for the comments and B stands for the book. So we're going to tell you where you can find it in unit 15. We're going to tell you where you can find it in Learn, Test, Pass. I'm also going to tell you where you can find it in previous units that we've discussed. So the first section, the first piece, we're going to differentiate between which activities do and do not require a license. We're going to talk specifically about the activities that the unlicensed assistant may or may not do. We're going to talk about different license categories in North Carolina. We're going to talk about very licensed statuses. So we're going to review things like current and expired, active and inactive. Does this sound familiar? Because this is a great opportunity to review Unit 1. So in Unit 1, we addressed these things. So you guys have it there. And remember, in Unit 1, the resource is that Real Estate Licensing in North Carolina booklet, the RELINK booklet. So a lot of that addresses our license categories. And that's also the booklet that tells you your steps for your application process, how do you apply for your state exam, that kind of thing. So the RELINK booklet can also be found in Learn, Test, Pass. So let's review. Talking about the license triggering events. There are 3 events that trigger a license, and all 3 of them must be present. So who needs a license in North Carolina? If you are earning compensation, any form of compensation, not just be money, anything of value, on behalf of another, and you are LL Beansing. We're going to break LL Beans down in a second. So it's a word now, right? So the transfer of real property for others for compensation requires a license. And all 3 must be present to have a license. So for example, if you are doing this for yourself, your name is on the deed, you are a for sale by owner or a for lease by owner. That means you're not doing it for another, you're doing it for yourself. Do you have to have a real estate license? No, because we don't have all 3 activities. What if you're helping your sister buy a home for absolutely free? No money, no lunch, nothing in exchange. Do you need a license?
No.
No, please don't do that, y'all. Please call me before you think you want to start working for free. I'm going to talk you out of that pretty quickly. But you guys are with me, right? If you want to work for free and no compensation, nothing of value. So all your sister can pretty much say is, thank you. Now you don't need a license. Why would you do that? I don't understand that. Seriously, call me. We'll talk about it. When we talked about LL Beans, what we're referring to are those activities that require a license. So list, lease, buy, exchange, auction, negotiate, and sell. LL Beans is one way to remember those activities. And by the way, this does include collecting a referral fee because you're referring to list, you're referring to lease, or you're referring to buy or sell. So referral fees, in order to collect a referral fee, you have to have a current active license. When is a license not required? Well, we got a couple exemptions. There's a few things that would not require a license. What do you think? Are exemptions for family or friends? I mean, we just gave the example working with your sister, right? So even though they're your sister, your family, your friends, you know, mom and dad, If your name's not on the deed, your deed may on the deed later, but it's not on the deed right now. So if your name's not on the deed, then there are no exemptions, even if it is for family or friends. The mere crier of a sale. So the auctioneer may be one and the same, but they may be two different people. You might have the auctioneer, and then you have the crier. The crier is the one that does the talking, does the bidding. The crier is the one that talks so fast you can't understand and like, hey, money, 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 you know, that guy. That would be the crier. The auctioneer, the auctioneer is duly licensed. The auctioneer will have a real estate license. They'll also have an auctioneer's license. They may have a crier, which would only have an auctioneer's license, but they're working for the auctioneer. So the mere crier of a sale doesn't need the real estate license. I had somebody with an auctioneer's license in pre-licensing. He was coming for the real estate part of it, but he was working on that process. And I tried to get him to cry for us so bad. He wouldn't do it. It's like, come on, man. He wouldn't do it. Also, no license required. If you're acting as a power of attorney, an attorney in fact, you're acting on behalf of somebody under this control, under this power, you don't need a license. Like we said, the for sale by owner or the for lease by owner, because you're not doing it for others, you're doing it for yourself. And that might be the individual, that might also be the entity, the corporation, the LLC. And then anybody that's court appointed. So maybe the administrator, the executor, etc. They would be exempt from a license because that court appointed admin is doing it for somebody. The court has given them the authority to do it for somebody. So knowing those exemptions when a license is or is not required. The other thing we kind of hit on tonight actually was our unlicensed assistants. It's not uncommon in your real estate firm, sales or property management to have unlicensed employees. You may reach a point in your career one day where you need help, and maybe you hire an unlicensed employee. Guys, always remember the real estate commission can only regulate licensees. They can't touch the unlicensed employee because they don't have a real estate license. So who are they going to hold accountable for? You, the employing broker, because you are the one that they can discipline because you are the one with the license. So your broker in charge, if you have an unlicensed employee in the firm, your broker in charge is responsible. If you're the employing broker, then you're going to be responsible. And when we get back from break in just a minute, don't go anywhere yet. But when we get back from break in a minute, we're going to review those permitted activities. So when you are ready to bring on your unlicensed employee, you can get a very clear step-by-step list about what that unlicensed employee is allowed to do. So we'll look at that when we get back from break, but I got one more thing to say. The other big thing about the unlicensed employee is how they are paid. The unlicensed employee can only be paid hourly or salary. They cannot be paid a commission, referral fee, bonus, because they're not licensed. And remember, to have a license is the transfer of real property for others for compensation. So if they're not licensed, they can only be paid that hourly or salary. Even if they refer you business, they may say, hey, my parents want to sell their house. Can you help them? I can't give them a referral fee. All I can do is thank them for sending them my way. You cannot compensate anybody without a license. The unsalaried or unlicensed employee is going to be a W-2 employee, which means taxes are withheld from each pay. Compare that to the broker that's a 1099, which means they don't withhold taxes. But guess what? At the end of the year, Uncle Sam's standing there saying, awesome, you had a great year. Pay up. So I always suggest, I always recommend your first year in real estate sales, at least your first year, talk to an accountant because they can help you determine how much to set aside for taxes. They can help you manage your money to run your business. You're going to have advertising and marketing and membership fees and dues. And guess what? You got to pay yourself as well. So the accountant can help you with that money. Is everybody good with that? Just a suggestion. But please don't wait till the end of the year and then be surprised when they're collecting taxes on your good year. That hurts many first year agents. Head bobs? All right, that was your free advice for the day. So let's take 10 and we come back, we'll look at those lists, that list of permitted activities of the unlicensed employee. Welcome back. Take attendance. And then let's look at the comments and let's see this pretty detailed list of what your unlicensed employee can do. So we're in the comments and we're going to scroll down to, starts talking about it on page 2. And then the activities that they can do is on page 3, first column. So what can your unlicensed employee do? First off, notice that said salary, that does not say commission. So what can they do? They can receive and forward phone calls, emails, etc. They can put listings and changes into the MLS as long as what they're inputting was providing to them by their employing broker. So they're not filling in the blanks on their own. It's data entry only. They can secure copies of public records. They can put signs in the yard, lock boxes on the property. They can order and supervise repairs for the property listed for sale or for lease. They can play courier, so they can deliver and pick up documents. They can provide basic factual information on the property. A kind of good rule of thumb here is if you and I can find it on Zillow or Realtor.com or whatever your favorite site is, that's the information that they can provide. So if somebody calls in and wants to know what it's listed for, since you can find that on Zillow, they can give that information. But if it's not accessible to the public, whatever the person on the phone might be asking for, then they would need to refer them to their employing broker. They can schedule appointments for showings. They can communicate with licensees, owners, inspectors. Number 10 says that they can show properties for rent. So they cannot show properties for sale, and doing an open house is showing a property for sale. So this is only unlicensed employees or the property managers that can show properties. Everybody good with that? Questions on that? They can type up offers, contracts, leases. They can fill in pre-printed forms, again, as long as the information was provided to them by their employing broker. They can manage the trust account. They can record, they can deposit earnest money, security deposit, etc. They can balance the trust account every month. Ultimately, the broker in charge is responsible for the trust account, but the broker in charge can allow their unlicensed employees to manage it should they choose. They can assist in putting documents together for closing, and then they can disperse commission checks once it's closed. So they could pay the agents on behalf of the firm. So it's pretty, here you go. This is what your unlicensed employee can do. You know, it might be a year or so before you guys are ready for the unlicensed employee. And what I would suggest to you is come to ncrec.gov, find the comments, and look at this list again to make sure you know what you're hiring that person to do is within the Real Estate Commission rules. Because again, you guys, they can only discipline licensees. If you don't have a license, they can't touch you. Questions on the unlicensed employee? Thank you. Talking about different license types. So for the individual, we're all brokers. We just have different categories. We got our provisional brokers and our non-provisional brokers. We have our provisional brokers We have our full brokers, and we have the broker in charge. We're all brokers. We just have a different category. The firm also has a real estate license. So they are a licensed entity. The firm follows the same license law and commission rule that the broker does. The firm has to renew their license every year, just like the broker does. And then there's a separate type of license called a limited non-resident commercial license. So we'll refresh that in just a second. Talk a little bit more about what that is. So you guys, my soon-to-be provisional brokers, soon-to-be PBs. You are a provisional broker and you want to activate your license. Does everybody understand? You go to Pearson VUE and it pops up on the screen where it says you pass. The Real Estate Commission will mail you a license, a nice 8.5 by 11 license. Once you pass, they're giving you a license that's on inactive status. Congratulations, here you go. Here's a piece of paper that you can't do anything with. Good job. So as a provisional broker, how do you activate that license?
Work under a BIC.
You've got to affiliate with a BIC. You've got to affiliate with a firm. You will remain inactive until you affiliate and or until you drop that provisional status. And we're going to refresh on post licensing in just a second. So you're going to affiliate with a BIC. And then, like we said, don't forget about that education. Don't forget about that post licensing. We're on that in a minute. That limited non-resident commercial broker is exactly how it sounds. You could have a broker from another state that comes into North Carolina to do a limited number of commercial transactions. This would be a separate license category, a separate license, and they'd have to go through the commission to get this permission. But that licensee has to have a license in good standing in another state. So it needs to be current or active or whatever their equivalent is in that other state. They come into North Carolina and they have to affiliate with a broker. It's almost like they got to be sponsored by a broker. Doesn't have to be a broker in charge. It could be a PB. But as long as they're sponsored by a broker, that sponsoring broker is going to be responsible for making sure that this broker from another state is doing it our way. When you're on our soil, you're going to do it the North Carolina way. And then, of course, they have to declare or get that permission with the Real Estate Commission. They're not going to be able to hold trust monies. They're not going to be able to have a trust account. So they are limited in what they can do. But, you know, if you're a broker in another state and big corporate USA hires you to go find me a couple commercial buildings, then you get this special license, you get this permission to come in, not residential, but you have this limited non-resident commercial license to come into North Carolina to do these few transactions.
Where is she over here?
Oh.
Let me see if I can pull up.
Okay, so the sole proprietor. Does the sole proprietor have to be a BIC, or does the sole proprietor have to get a BIC, hire a BIC?
No.
It depends.
There it is. The answer is, it depends. So as a sole proprietor, you may or may not need a BIC. As a sole proprietor, do you need a BIC? The questions are you going to have a trust account? If you're going to have a trust account, you either have to be a BIC or get a BIC, hire a BIC. A sole proprietor, if you're going to market or advertise your services in any way, you either need to be a BIC or get a BIC. And then if you're going to bring on more than one broker, more than just yourself, again, you need to be a BIC or get a BIC. So you can be a sole proprietor and not be a BIC as long as you are not doing any of these three activities. As soon as you have a trust account, as soon as you market or advertise your services in any way, or as soon as you have somebody else affiliated with you, now that sole proprietor has to be a BIC or get a BIC. So what do you mean? What can I do without a BIC? You guys are pretty much working on referral business. Quite frankly, this is my retirement plan. One day when I retire, I'm going to hand over my book of business to a young licensee, a newbie right out of pre-licensing. And I'm going to say, any business you get from this book, you're going to pay me a referral fee. So I'm going to keep my license active. I'm going to have my toes in the sand somewhere. And this is how I'm going to spend my retirement years. And that's how most sole proprietors are. Because remember, you're not marketing, you're not advertising. So you're pretty much just in business to collect referral fees. You could represent your family and friends. A good rule of thumb is those that should reasonably know that you have a license. I'm not marketing, I can't advertise myself, but don't mom and dad, shouldn't they know I have a license? What about my BFF, right? So I could work with them in transactions because it makes sense that they know that I have that license. That's the key. I'm going to go back for 1 second because I think that's the one that's hardest for us to get. You cannot market or advertise your services. If you're going to advertise your services, you have to be a BIC or get a BIC. I'm talking anything on social media, handing out a business card, letting the public know that you have a real estate license would be marketing or advertising your services. So again, you're pretty much referrals representing family and friends. Those that should know that you have a license. So advertising properties for sale or lease, also advertising yourself. Isn't saying, call me, I can help you buy a house. Isn't that advertising my services? So it's not just properties for sale or lease, it's yourself as well. If you're going to do that, be a BIC or get a BIC. Questions on that? Can you say you passed a test on social media? That's a great question. And I would probably be careful because if you're saying I passed my real estate exam, what are you telling people on social media? Without saying it,
You're an agent.
Call
you're
me.
telling them that you're an agent. You're telling them, yep. So even if you're not saying it. Now, once you affiliate, then you can go all over social media and say, hey, call me, right? I can help you buy or sell because now you're affiliated. Now you have that active license. And remember your BIC, especially as a provisional broker, your BIC needs to approve your advertising before it goes out. We know how the internet works, right? When you hit submit on social media, it's gone and it's really hard to get back. So the BIC needs to approve that advertisement before. Great question.
And you have to have the agency's name on there or the firm's name, right?
And you have to have the firm's name, exactly. So if you're not affiliated with a firm, you don't have anybody, right? So I remember there was a thing about that blind ad. There was a thing that came up in a class a couple years ago. And the agent went on social media and said, Beyonce's coming to town. I want tickets. Buy a house for me. Was that a blind ad? Because she was advertising her services. Yeah, she wanted to go see Beyonce, but she was advertising her services as a broker. Call me, I can help you. So again, you guys, we got to think, think before you hit submit. And this is why definitely we need to make sure our BIC reviews it before it goes out. So how do you be a BIC? Well, to become BIC eligible, you first have to have an active license, not on provisional status. Makes sense, right? Active license, not on provisional status. you have to have some experience. So 2 years full-time or equivalent part-time within the last 5 years, or you have some kind of exceptional experience. Maybe you were licensed in another state and now you've moved to North Carolina. So you have that experience in the other state. They may approve you to be BIC eligible. So you have an active license, not on provisional status. You have some experience. And then the third piece is there's a 12-hour BIC course. Doing these 3 things make you BIC eligible. Once you are BIC eligible, what that means is you are eligible to become the designated broker in charge. Every single office location has to have a designated broker in charge. I need a BIC under every roof. Not every firm, but every roof. So if your firm has 5 offices, how many designated BICs do they have? They have 5. BIC under every roof. And there's a lot of debate right now, the commission, about what the BIC's responsibilities are. They've been looking into this quite seriously for the last couple years. But one thing they are in agreement of is that the BIC's responsibilities should be, and the easy way to remember this is 3 A's and 2 T's. So the designated broker in charge is always going to be responsible for agency. Are your agents doing the working with real estate agent disclosure? Are your agents properly completing the agency agreements? Exclusive right to sell, exclusive buyer agency, and property management if that's where you are. The BIC is responsible for all of the advertising that comes out of the firm, comes from their agents. That's why we just said, make sure your BIC approves it before it goes out. And the BIC is responsible for making sure that all their agents stay on current active status. So they may check in with you throughout the year. Have you done CE? When the renewal period hits, they're going to ask you 20 times, have you paid the renewal fee? It's their responsibility to make sure that you remember to keep your license current and active. If the office has a trust account, then the BIC is responsible for that. They may have an employee maintaining it, but ultimately the BIC is responsible for the trust account. And then they're responsible for all the transaction files, making sure that the files are complete, making sure that they're in compliance, and making sure that we maintain them for at least 3 years. 3 years is the minimum. Questions? So this next little section, we're going to talk about some various license statuses. We're going to talk about the educational requirements to maintain those statuses. So we are still reviewing Unit 1 and the real estate licensing in North Carolina, the ReLink booklet. So when it comes to license statuses, the first question to ask yourself is my license current or expired? How do you have a current license? What do you have to do?
Pay your fee.
Pay money.
Show them the money. We pay a renewal fee every year during the renewal period. The renewal period is May 15th to June 30th. Don't need to know that, but just know there's a specific time period that we have to pay the renewal fee. Paying the fee, showing them the money, makes your license current. Failure to pay the fee by June 30th at 11:59 p.m. means on the stroke of midnight of July 1st, your license is expired. Current versus expired has nothing to do with education. It has everything to do with money. Why don't y'all write that down? It has nothing to do with education. It has everything to do with money. You can take all the dang CE in the world, but if you don't pay that renewal fee, your license is expired on July 1st. What can you do with an expired license? Nothing. Nothing at all. Zero, zip, zilch. Yep. So everybody good. Current versus expired. It is all about showing them the money. So if your license does go expired, how can you reinstate an expired license? Well, it depends on how long it was expired. So if you wake up on July 1st and go, oh my goodness, I didn't pay the renewal fee. Are you kidding me? It's cool. You less than 6 months, you pay that renewal fee, you pay an application fee. This year they've been $45. I keep hearing noise, it's going up to 50, but whatever the renewal fee is, the application fee is the same. So you pay the 2 fees, submit your renewal notice, and poof, you're active again. If your license is expired for more than 6 months, but less than 2 years, you're going to pay the renewal fee, you're going to pay the application fee, and now you have choices. You can either go back to Pearson VUE and sit through your state exam again, or you can retake 2 out of 3 post-licensing courses. The good news is you get to pick your favorite 2. So whatever your 2 favorite post courses were, those were the 2 you can do. The thinking here, you've been more than 6 months, but less than 2 years, you might have lost some updates. You might have lost some new laws, new rules. So they want you to have some kind of current education. If your license is expired for more than 2 years and you decide you want to get back in it, call Lane. She'll get you in my next pre-licensing class. Y'all, pay the fee. I'd love to see you guys again, but not here. Pay the fee. You could ride for the rest of your life on an inactive license. All you have to do is pay that renewal fee every year. So many times life comes up and agents think, I'm done with real estate and I'm going to save $45 a year and I'm not going to pay the fee. And then something comes up and you go, I want to get back into real estate. And you call the commission and you say, that was 5 years ago. What do I do? And the commission's going to say, find you a good education provider, get yourself enrolled in pre-licensing. Does this hurt you a little bit? It hurts me every time I see this. It pains me every time I see this.
Have you had any students go through that?
The last in-person class I taught before the pandemic, I had 2. Unrelated, didn't know each other. I'm like, are you guys kidding me? And they're like, man, did we learn a lesson? And let me tell you, I check in on them every once in a while and they're both still active. So I do believe that they have, they have learned their lesson, but that hurt. If I want to get a license in another state, I would just have to take the state exam. The answer to that is, it depends. There's a word that I never say right, and it's reciprocity. If the states are reciprocal, then they may just make you take the state exam. But if they're so different than North Carolina, then they may require you. So what I have to say to you is call that state's real estate commission. So call the South Carolina Real Estate Commission and say, I got an active license in North Carolina. What do I need to do? Does that make sense? So expired license more than 2 years. I'll see you back in pre. Once you pay that fee, your license is current, and a current license can be active or inactive. The difference in an active or an inactive license is typically education, but really the big difference between the two is whether or not you can get paid. I can only get paid with a current active license. So it's current because I paid the fee, and then it's active because my education is up to date. You guys have done your post-licensing on time, or we've done CE on time. Going to talk about both in just a second. Don't do your education, your license is inactive. Provisional broker without a BIC, your license is inactive. Or you could choose to have an inactive license. Again, maybe you think you're done with real estate. You could ride forever on an inactive license. All you have to do is pay that fee. I have heard instructors say that they have told their family that if they go on life support and May 15th hits, pay the fee for me. Sounds like good advice, doesn't it? Can you have as many active licenses in other states? Hear ya. But yeah, you could be active in all the states if you wanted to. I'm concerned about taking over North Carolina, but you're ready to take on the country. I hear you. Remember that reasonable skill, care, and diligence. Talk to me about zoning in Utah, right? You got to have that reasonable skill, care, and diligence. So pay the fee. You could ride forever on an inactive license. If you don't do CE while you're inactive, when you're ready to activate, they may get you caught up on education, but you can take CE on an inactive license. So my advice is if you think you're going to reactivate, go ahead and take CE. So then that way, when you're ready to activate, it's literally the submission of a form and you're back up and running. CE requirements, we do 2 4-hour CE classes each year. One of those classes we do is the update. The update is the same material across the state. It's the Real Estate Commission's opportunity to make sure we're all updated. There are 2 update courses. There's the general update, which is for PBs and full brokers. And then there's the broker in charge update, which is for BIC eligible and designated BICs. So just make sure you're taking the appropriate update, general update or the broker in charge update. The other 4-hour class that we do is an elective. The elective is a topic of your choosing. As long as it's been approved by the commission for elective, CE elective credit, then you can take that. And most schools will tell you if you're going to get CE credit for elective credit for this class or not. When it comes to the elective, we could choose which topic we want. And what I always suggest is find an elective topic that caters to your career. What do you want to know more about? What topic can you have to help grow your career, advance your career? I mean, there are so many elective topics out there. So you could search, the school will tell you what elective topics they offer, but you can also go to ncrec.gov and there's an education tab. And under the education tab is CE. And you can do a search for different elective classes throughout the state. And today, not all, but quite a few are still on Zoom. So this kind of gives us the opportunity to take an elective class, like Wilmington or something. But again, I don't know. I always thought of the elective as like 2 birds, 1 stone. I have to take it anyway. So why not choose a topic that can advance my career, give me that education, that knowledge. I'm going to say pick a topic about real estate, and there's a pretty good chance that there's an elective credit out there for you. What's the CE deadline every single year?
June 10th.
June 10th.
June 10th, June 10th, June 10th. We have to have CE done every year by June 10th. The Real Estate Commission works on a physical year. They do not work on a calendar year. It's a physical year. The Real Estate Commission's year is, here's my timeline again. The Real Estate Commission's year is July 1st to June 30th. So as we mentioned, that renewal period is May 15th to June 30th. And that's why we have to pay that fee before June 30th. We got to pay during the renewal period. CE deadline is June 10th. Y'all, they start offering CE like August. So you don't have to wait until May or June to take your CE. We also refer to May 15th to June 10th as CE season, because everybody's trying to get in to get their CE before their deadline. But they've been really making a push lately. As soon as they make the material available in like August, you can go ahead and take your CE. So you don't have to wait. I actually caution you guys not to wait because this deadline is a hard deadline. And there are very, very few exceptions for an extension. I'm talking like active military deployment kind of thing, right? So it's very, very few. You can't call the commission and say, I got busy working with buyers and sellers and I forgot to take my CE. That's not considered a hardship. So failure to do CE by June 10th, they cut that off because they have everybody renewing. Brokers are renewing, firms are renewing, real estate schools are renewing, educators are renewing. Everybody has to renew every year. So there's a lot going on at the commission during this time. So they cut that off on June 10th to allow them to process. So when they start their new year on July 1st, everybody starts with a current active license, as long as you paid and did your education. If you pay the fee, but don't do CE, what's your license status on July 1st?
Active.
You are inactive. You're current because you paid the fee, but you are inactive because you didn't do CE. Please, please do not wait until June 10th to do CE, please. Questions on CE? So then once we get you through this weekend, the next thing you guys to have look forward to is post licensing. So we get you through this weekend, then you go take your state exam. You got to complete post licensing. Anybody remember how long you have to complete post licensing?
18 months.
18 months.
15 months.
So 18 months from licensure, you have to complete post licensing. So what I want you guys to do, the day you pass your state exam, go out and celebrate. That's the big celebration, right? And don't forget to text me and tell me you passed, because that's why I do what I do, is for that text that I get from you guys. So don't forget to tell me. But once you, the day you pass your state exam, that is your licensure date. And that's when your 18-month clock starts. So what I want you to sit down on that day is look at your calendar and make sure, no matter what your plans are you ready to affiliate and start your brokerage business? Or you want to knock out posts before you affiliate? There's no wrong way to do that. But what I need you guys to know, no matter which route you go, do not let that 18 months get away from you. Failure to complete all 3 post licensing within 18 months means that your license will go inactive until you're done, even if you're in the throes of a transaction with a buyer or seller. So please, please, please don't let that 18 months. And by the way, when we say complete post licensing, there are exams at the end of each 3 post licensing classes. But guys, listen, post licensing is not near as intense as pre. You're doing the hard part now. You're proving yourself now. So once we get you into post, we'll definitely get you through it. Everybody good with that? So we got 3 topics, 3 post licensing topics. 301 is brokerage relationships and responsibilities, which is a fancy way of saying agency, which is what we looked at in units 3, 4, and 5. 302 is contracts and closings, which is pretty much our units 8, 10, and 11. And then 303 is law and rule, which is what we're doing right now. You got to do all 3. The order doesn't matter. You can take them in any order that you want to, but you got to do all 3. You got to successfully complete all 3 within 18 months of licensure. Questions on this?
Miss Julie,
Uh-huh.
but we have to be affiliated with the firm in that time, right? To
Nope. You
No?
can take post licensing inactive. So
Okay.
you can either get your license and affiliate and then do post, or you can get your license, do post, drop your provisional status, and then affiliate. There's no wrong way to do that.
Oh, okay.
As a matter of fact, I do 302 mostly because it's got the math. So y'all know me by now, right? So, and I'll do 301 a couple times, but I don't like 303 because it's all the law and the rules. So luckily for Lane, she's got a good mix of us that likes to do our own thing. But it's interesting because when I do post licensing, I can almost always divide my class in half. Half of you are active and half of you are inactive. So there's absolutely no wrong way to do it. You don't have to do it in any order. You just got to watch that 18 months. Other questions?
And what's the hours for that again?
30, each one is 30 hours. So for a total of 90 additional hours. Y'all, we have danced all around the real estate commission, but in this next section, we're going to meet our commissioners and we're going to talk specifically about what they can do. So we're going to talk about the purpose and the composition of the real estate commission. And then we're going to talk about our licensees, our responsibility to communicate with the commission. When do we need to notify the commission? What are some duties, some agency duties that the commission tells us? Wow, this sounds like a new section. I guarantee you a lot of this has come up just in our discussion together. So it's like kind of review, kind of, sort of, not really. So here they are. Let's meet your North Carolina real estate commissioners. We have 9 members. There are 9 commissioners, and they're all appointed. 7 of them come by the governor, 1 come by the Speaker of the House, and 1 comes from the pro tem. Each commissioner serves a 3-year term. Of the 9 members, at least 3 of them have to have a real estate license. But also of the 9 members, at least 2 of them have no involvement with real estate whatsoever. What's their main purpose? I see in mouths. To protect the public. So 2 of them are at least 2 of them are a true representative of the public that they are protecting. At least 2 of them don't have any involvement with real estate. Isn't that interesting? I always find that very interesting. So they're a true representative of what they're doing. They're a true representative of who they're protecting. So their main purpose, why do they exist? Is to protect the public when they're dealing with me and you. Some of the power, some of the rights that the commission has. They educate, they provide education. For brokers, that education comes in the form of pre-licensing, post-licensing, and CE. They also help educate the public, and they do so by having a plethora of information on their website. Once you guys get licensed, make a mental note to yourself. Once you guys get licensed, I want you to spend some time on ncrec.gov because there's so much literature out there. There's so much information. And the Real Estate Commission says, if we have it on our website, you can use it when you are working with the public. So take advantage that the wheel has been created. So if all those Q&A brochures that we've seen, they all come from the Real Estate Commission. Any of the documents, anything that they have, it's all meant to help to educate the public. And we are welcome to use anything because that's a lot of what we do too. We help educate the public through the transaction, through the process. The other thing that the Real Estate Commission can do is they can discipline our license. The North Carolina Real Estate Commission gives you your license, giveth you your license, and guess what? They can taketh it away. They can reprimand, they can discipline your license. Remember, you guys, they can only discipline licensees. So they can't touch the unlicensed employee. They can't touch unlicensed sellers and buyers and landlords and tenants. They only can discipline, they can only regulate licensees. And how they may discipline your license, they may reprimand you, which is kind of a slap on the wrist. Don't do that again. They may make you take a certain CE class or classes. They may deem that you need a little bit more education to satisfy that you won't do that again. They could suspend your license. I've seen suspensions for 2 weeks, or sorry, 2 months. I've seen suspensions for 2 years. You're not going to be able to practice brokerage activities when your license is suspended. To reinstate your suspended license, follow the same things that we talked about with the expired license. Less than 6 months, 6 months to 2 years, or more than 2 years is how you would reinstate a suspended license. And again, they may require you to take additional education as well. They also have the power to revoke your license. And if they revoke your license, they're taking it back. The answer to what are they going to do? It all comes down to how badly did you harm their public? How badly did you hurt their public? Is what they're asking themselves when they're determining what they want to do to your license. We have the option to surrender our license. So if you go through disciplinary action and you decide it's not looking good for you or you don't want to deal with it, you can turn your license over and you're done. Always remember, the Real Estate Commission isn't going to fine us unless, does anybody remember that exception? What's the one time they can fine us?
Timeshares.
Timeshare developers are the only time that they can fine. The rest of the times, the commission's not going to get involved with matters of money. They can't fine me. They can't make me pay the injured party. All they can do is discipline my license. So they could also suspend or revoke your license. And we're going to talk about this more tomorrow night. But if you've been convicted or if you've pled guilty to any of the following: embezzlement, fraud, forgery, or moral turpitude. Moral turpitude is just an act or behavior that goes against standards, that goes against common standards. So if you're found guilty of any of these, I mean, think about embezzlement. You've like embezzled somebody else's money. How are you protecting the public when you're now dealing with earnest money deposits, due diligence fees, security deposits, trust accounts, wherever you are? So you've mishandled money in the past with embezzlement. The concern is that you're going to mishandle money again. Every single disciplinary action is handled on a case-by-case basis. So you can't look at me and say, well, if I do this, what's going to happen? I don't know. I'm not the Real Estate Commission, but they review all the facts, they review all the information, and then decide what, if anything, they're going to do. Commission doesn't get involved with commission. That's the best way I know to remember that. The commission doesn't get involved with commission. So if you're not happy with what your firm is paying you, if you're not happy with the commission split, find another firm. Do not call the Real Estate Commission. They can't do anything. Remember, the firm sets their own policy. They set their own commission split. So if you're not happy with your commission split, just find you another firm. We're independent contractors. So when can the commission discipline a license? Well, they could just show up in your office one day and say, hey, show me your files. Let's see all your working with real estate agent disclosures from the last 3 years. They could also investigate after receiving a complaint. So if the injured party hires an attorney, there's a good chance that the attorney will want to get involved, get the commission involved. The injured party also has the ability, man, right there on NCREC's homepage, right there next to where you guys apply for a license, almost right next to it, it says, file a complaint. It's so easy for the consumer to find. So if the consumer clicks on that button and file the complaint, then that may launch an investigation. Now let's understand something. Just because somebody files a complaint doesn't mean that they're going to investigate, that they're going to discipline you. They're going to file the complaint. The first thing the commission is going to determine is there a violation of license law and commission rule? Is there reason to take disciplinary action? I mean, we know Yelp has made us all online critics, right? So does this person have a legitimate complaint against law or rule, or are they just blowing off steam? So that's the first thing they're going to do, is determine if there's an investigation, if it's warranted. If they determine that the complaint is warranted, it is in fact a violation of license law and commission rule, the real estate commission will send you what's known as a letter of inquiry. The letter of inquiry comes in an email. The letter of inquiry is your opportunity to respond to the complaint. They want to hear, look, there's 2, if not 3 sides to every story. So before they make a ruling, before they suspend your license, this is your opportunity to say, this was my side of the story. Y'all think you're going to be able to call the commission and explain over the phone? Nope. How do you respond? With your documentation. What do we document? Everything. They're going to ask for working with real estate agent disclosures. They're going to ask for agency agreements. They're going to ask for any other documentation that relates to the complaint. Do you have email correspondence? Do you have text messages, communications between the parties about the complaint? When we say it's your opportunity to respond, I mean you need to respond with every piece of paper you have that relates to this complaint, because that's how you tell your story. That's how you tell your side. With that letter of inquiry, you have 14 days to respond. Even if you did nothing wrong, you still have to respond. Failure to respond is a violation of license law. So you're as innocent as they get, but you didn't respond, you're still getting disciplined for not responding. Everybody with me? So you always have to respond. Once you get one of these, you always have to, if you get one of these, you always have to respond. While they're investigating, anybody involved, they could put in an injunction. An injunction is just a legal stop. So if the commission puts an injunction on you while they're investigating, you're not practicing brokerage activities until they get to the end of this. If there's any unlicensed people involved, then they could put an injunction on them, have them stop whatever activity until this is being investigated. If you're found guilty, they will reprimand, suspend, or revoke your license, whatever. During the investigation, you may be asked to come to a commissioner's meeting, stand in front of the 9 commissioners, and state your side of the story. But guys, remember, always remember, at any time during the investigation, from the time you get the letter of inquiry on, You're always welcome to have your own representation. And if you're invited to go to Raleigh to stand in front of the 9 commissioners, please take an attorney with you. You're always welcome to have your own representation. So you've been found guilty. They discipline your license. They're going to post it in the monthly bulletin, the monthly e-bulletin that comes out, like your name, your city, your firm, what you did and what they did to you. They're also going to print it in the local paper. It's a big deal. That's what puts the fear in me. I don't want to be in the disciplinary action, right? I mean, and that's how, I mean, seriously, isn't that a great way to conduct your business? Will this cause me to be in the e-bulletin? And if you answer yes to that, then please don't do it. Or if you say, I don't know, then get with your BIC, find out. Everybody with me? We're violating license law and commission rule. And that's what this whole class is about, is building that foundation. That's what post licensing about, is continue your education, CE. We want to keep you guys out of disciplinary action. You know, I've said all along that my job is to prepare you for the state exam. And that is, I mean, that's what I do. But I think the second piece of my job is to help you keep your license once you get them. You guys worked hard for it. So don't do anything stupid. Promise me? Okay. So 75%. Yep. Use your T-bar, 140 times 75%. Questions so far on the commission? And they're lovely people. I've met a handful of them. Several are involved in the education department. You can find some of them teaching CE, that kind of thing. So they're great people, shaking their hands, hobnobbed, but they still hold a very, very high power over us, don't they? To make sure that we follow those license law and commission rules. I'm gonna end it here tonight just because I don't want to start a new section and not be able to finish. So don't go anywhere yet. Let's talk about tomorrow. Tomorrow's it, you guys, for us, until we meet again in post. So tomorrow night, we're finishing 15. We're hitting the highlights of 9, 12. Let me get that right. Yeah, the highlights of 9, 12, and 14. We're talking about agent safety, one of the most important topics I have that's not testable. And then if any time allows, I'm going to open it up for a Q&A. So any questions you want to go over, anything you want to address, and remember, I'm still available via email, so you don't have to wait to bring your Q&A tomorrow. If you want a Q&A tomorrow, shoot me an email, shoot me a text. Friday I'm around, Thursday I'm around. But if we have time tomorrow, we'll open it up for Q&A. And then we'll be done. Questions? It's hard to believe, isn't it? I feel like it was just yesterday that I was going, hi. But here we are. Slow down time. All right, y'all have a good night. Please sleep these next couple nights too. Don't pull all-nighters. Y'all need your sleep. All right, good night. We'll see you guys
Thank
tomorrow.
you.
Wrapping it all up.
Thank you.
Good night. Thank you.